All right, board. Mr. President, are we ready? All right. Okay, folks, we are back on the record, ready to try to wind this up. Mr. Mickey, would you be so kind as to call your next witness?
Yes, sir. Please meet Dr. Council Powell. And to start, will you introduce yourself to the board?
1 second. Dr. Powell.
Oh, jump the gun.
Yes, where are you in? Not that I'm not positive you're going to be completely truthful, but this just form over function here. You swear or affirm the testimony about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you, sir. Go ahead, Mr. Mitchell.
Will you introduce yourself to the board, Dr. Powell?
Yes, my name is Council Powell Jr. I'm the Region Director for CVS Health for Region 62.
And could you tell the board a little bit about your educational background?
Yep. I'm a graduate of Xavier University College of Pharmacy, where I obtained my PharmD. I'm originally from Mobile, Alabama as well.
And what did you do after you graduated from pharmacy school and obtained your PharmD?
Yep. I actually started my career with Target. Let me go back. After I finished, I moved to DC. I was supposed to start law school. I started working, enjoying myself. I didn't go. So I wound up moving back to be closer to home, which was Mobile. And I started my career with Target Pharmacy prior to the acquisition. And that was in 2001. Go ahead. I'll continue. I was promoted to a field leader with Target. I had all of South Florida at one time. It was called a group pharmacy leader. So I oversaw all of the stores in South Florida for Target. Then I took a lateral move to get back home. I wasn't married at the time. My sister had 2 nephews, so I wanted to get back closer. So I wound up taking another group pharmacy leader role based out of Louisiana. Did that for another couple of years. Then I had an opportunity to come on board with CVS in 2009.
What capacity did you join CVS?
I joined CVS as a pharmacy supervisor. At the time, back then, they had district managers and pharmacy supervisors. So I started as a pharmacy supervisor. They had me do that for about a year, and then I was promoted to district manager. I did the district manager role for about 6 years, and then I was promoted to region director in 2017.
And is that the position you still hold, regional director?
Correct. Yes. I was promoted within the market. I came up in Louisiana initially. They did move me to Dallas. I was in Texas for 2 years during COVID as a regional director there. Once again, post-COVID, opportunity came up to get closer to home where my parents were, and I had kids at the time. There was no way I wasn't going to go home. So now that's the current role that I'm in.
And is Arkansas a part of your region?
Yes, it is. So the breakdown of my region currently, I cover Alabama, Mississippi, Louisiana, Arkansas, and the 9 stores in Missouri that Ashley mentioned. I picked up Arkansas at the top of January of 2023, last year.
Give the board an overview of your responsibilities and just what do you do as a regional leader for CVS?
As the regional director, I'm responsible for the culture within the market. I have 11 district leaders that report to me. I work for them. So my goal is to support them, make sure they have the right development, how they're actually leading their teams in stores is my primary role. Then also just identifying talent throughout the market when you come across pharmacists that are doing a fantastic job, caring for their community, giving folks opportunities to advance in their career as well.
Dr. Ellis talked a little bit about some of the programs that CVS employs to promote high functioning pharmacies and safe pharmacies. I don't want you to, I'm not asking you just to repeat what she said, but I would like for you to comment, if you don't mind, about some of the programs she mentioned and then anything you'd like to add to that.
Yeah, I've been with CVS for a while now, time flies. Our focus on safety and quality is the highest that it's ever been. The goal that I have in place, or the expectation is when you go into our pharmacies and talk to the pharmacists, what's your primary responsibility to your community is safety. It's providing a safe environment and the quality care for their patients. So prior to these stores being audited in 2020, since then we've rolled out, you heard about OPI, which is Operational Insights. It's really four
I'm
prongs.
going to object at this point. It appears that the witness is testifying from some information from his cell phone. He's done it more than once. I don't know what he's looking at, and I think that needs to be identified for the record.
Doctor, what are you looking for on your
Just
phone?
notes.
Oh,
It was actually my
notes?
personal, just notes from myself.
Right.
Can't do it, won't do it.
Okay, I'm gonna go ahead and overrule Jeff. If he's using his own, if these are your own notes?
Yes.
Oh, all right. Objection overruled. Please proceed.
Okay. So with regards to, thank you, OPI, we look at four things. We look at regulatory, as you heard Ashley discuss, regulatory events, pharmacy practices. We also look at inventory. And then the last part was the team health, scheduling, and how we're handling and meeting the needs of the business. You also heard her refer to SMART DUR. So this was something that brought a lot of joy as far as to me personally, what we did. It was built from the ground up by pharmacists. And it's basically giving more guidance for drug-drug interactions. So when they occur in stores, our pharmacists are able to slow down. It gives them the actual next best steps and recommendations that they must take, whether it be phoning the physician, talking to the patient, so they don't have that need to refer to a different reference, another reference, or move or go and look something up. So it's been very, very well received, and it really shows it was a big investment we made as a company to show how important safety was or is to us.
And then what about We Care, to the extent there's anything you want to add about what?
We Care is how we identify how well a pharmacy is operating efficiently. It talks about, you heard Ashley mention ready when promised. That's, hey, is the prescription ready when a patient appears? Based on what they said, or if it was an acute medication. We look at carryover. You heard her saying, are stores carrying over work to the next day? And we'll even look at call wait time. I think everybody can agree, if you are not answering phones, what does that do for our patient's experience?
Dr. Powell, could you explain, and particularly with CVS, what is the difference? What are some of the differences between a pharmacist that's working overnight versus a daytime pharmacist?
Yeah, our overnight pharmacists, very interesting as well, right? But they are by themselves. They're in charge of ready fills. Once again, you heard those are prescriptions that aren't due at 8 a.m. They're due the next day or further days out. They also can do return to stocks as well. They also can help if there's any catch up from the previous day that they've seen. They're responsible for that as well. So they have duties overnight. As you may know or understand, there are not a lot of 24-hour pharmacies even left from that perspective, from a quality of life and just productivity. So their primary goal was a lot of ready fill. I would seldomly go in and see someone having waiters come in at that time. So it's primary ready fill and any other duties that needed to be assisted from the day shift.
There's been some discussion and questions about prescription counts and how many prescriptions a store is filling in a given period of time. Now, I've heard, not in this proceeding, but otherwise separately, that there can be some variations in how a prescription is counted, and specifically a 30 is one, or a 90 is three, or a 90 is one. Can you explain what all that means?
So for example, if you ask one of our pharmacists, we do have reporting that shows scripts 90 is three. So that's a 90-day supply that's counted as 3 months, or 90 is one. True script per week is 90 is one. So there can be some confusion. Here's the good news though. If you ask us for that, they have access and we can actually show you in stores what their volume is. They now have a dashboard that shows them scripts filled per day, 90 as one.
So for a 90 is three, if they're counting a 90 is three, I want you to just break that down a
It
little
will
bit.
inflate the number. So for example, it'll show 90 is three, 2,800 scripts per week. That's not 2,800. That's not 90 is one. That 90 is one number, of course, is lower. And that's the actual, how many times it's touched. It's only touched once. It's filled. It's a 90-day supply. So that's where we own some of the confusion. And then too, I also see when you ask pharmacists historically, how many you fill? Counsel, I'm filling 700 a day. Let's pull it up and let's look at it. No, you're filling 350. 300. So, but we can provide the exact number per day stores are filling.
Tell the board about how CVS in Arkansas and your stores in Arkansas are doing now.
You guys, I think it was talks on why was I fidgeting or whatnot. Just proud of the work she's done. So coming into it, as I said before, I picked up this market in January of 23. The previous leader exited the company Christmas of 22. So when we first started, we didn't have a leader in place. So having her come in, she mentioned she had pharmacist openings. As you know, if you have the wrong leader in place, typically folks don't leave because of the company. You leave because of who leads you. So she came in and did a wonderful job on just connecting with people and closing the staffing gaps we had for pharmacists. So I'm proud to say now currently she only has 2 openings, their staff positions, one inside of a Target and then one in Jonesboro, the core store, excuse me. Both in Jonesboro, excuse me, not Target. She doesn't have Target. Sorry.
And specific to the 3 stores in question today, prior in preparation for today's hearing, did you have the opportunity to take a look at those stores, numbers from those stores, staffing, just how those stores were doing overall?
Yes. And I didn't explain. So the market that I have for Arkansas, there are 23 total stores in Arkansas. She has 15. And then there's one store that is not in my region. That's the Texarkana store. But I did review that information on that store. Bella Vista and Sherwood are under my umbrella. So yes.
And is Texarkana, that's just lumped in with Texas, with that a different region?
Correct. It's
Yeah.
the region director is Nana. He's in Houston.
And how are we doing in Arkansas?
Yes. We, once again, recognition goes to Ashley Ellis. So the culture is like the biggest part to me. When the culture is right in stores and you're treating people fairly, results that we as a company want to see, they come forward. So we're trending in the right direction. So can't be more pleased.
I know the board, and I'm sure Ms. Viles will have some questions for you. And so
Bales.
I did it
I
again.
got Ashley Bales. He's got it.
Bales.
We got it.
I'm sorry,
I got
Ashley.
it.
So I will pass the witness to Ms. Bales.
I just have a few questions. I feel like you've been testifying all morning because you've been bobbing and weaving and gesturing and
Trying
kind
not
of
to.
rooting on Dr. Ellis there. But when you said you're responsible for the culture.
Mhm.
So as part of being responsible for the culture, do you look at where your systems have failed?
Do I look at where the systems has failed? What we do is we receive updates on enhancements that come based on opportunities, but I wouldn't necessarily say where the system failed, if that makes sense. But the advancements we've seen are due to, hey, we've identified root causes to issues and they work on fixing them, if that
But
makes
there's
sense.
nothing in your experience supervising that you've been like, okay, this just flat didn't work.
Yeah, over 15 years, yes, ma'am. And
What are those examples, I guess?
waiting bin comes to mind.
What's that?
Waiting bin. So the-
Waiting bin?
Waiting bin. So that's where you house all of the prescriptions that are ready for pickup for patients. So previously in our company, we had waiting bins that were done alphabetically, right? So you can have the A's, C's, right? Smiths, it would be packed full because how many Smiths are there compared to another letters, right? The company did that enhancement to where we changed and did a numeric waiting bin that assigned placement just from a space constraints and causing issues with stores. That's the first thing that popped to mind. The reason why that popped to mind quickly, the teams loved it. It was like, yes, this is the right thing to do because they were having challenges storing prescriptions where they go, if that makes sense.
Do you have any examples where the system, as again, if you don't want to say failed, if it just didn't work in the past that had to do with errors or mistakes by your pharmacist?
I was excited too, sitting here when we discussed handwritten scripts. Our technology now can address and identify errors in data entry from handwritten scripts. So that's recent. That's just happened within the last couple weeks, probably a couple months, I'd say. That I was just in the store last week in New Orleans, and a new hire was talking about, like, wow, I was impressed the fact that it identified a handwritten script error. As we said, the electronics transpose over. Our systems have enhanced to where it can actually identify errors that way as well. That's new though.
Do you through your metrics or your systems know the error rates for your stores that you're in your area?
No, we don't readily receive those. No.
Why don't you receive those?
Above my pay grade, not sure. It's just not what we receive. We receive, I guess, where we go back to, yeah, that is true. We always encourage reporting of errors. So possibly, I think why we don't receive them, because we don't want people to feel that they shouldn't report. The way that we improve systems is by finding out what the root cause of the error was so we can address it, whether that be retraining, whether that be system enhancements.
Have you ever done an audit of a store for accuracy yourself?
No.
And you, like Dr. Ellis, have taken on these Arkansas stores in January of 2023, correct?
Yes, ma'am.
And if a pharmacist, a shift pharmacist, not in management, if they had an issue, there's several layers that they would have to go to. Would it even get to you, or would it stop at Dr. Ellis, or what would that look like?
There is a chain of who they should contact. But my approach, and I'm not saying every region director is like this, everybody gets my card. I want them to call me. They can. They have that access. So technicians, pharmacists, but typically, yes, they'll reach out to their district leader. They'll reach out to the district support pharmacist, who you heard her mention is over the floater pharmacists. And we even have emerging leaders that are growing, preparing to become district leaders. That's a point of contact as well.
Have you had any contact in your role as regional director, or even before that, any contact with any members of our staff here at the Board of Pharmacy?
Brandon only, I want to recognize him as well. Like when I came into the market, some of the first early visits I had, when there were opportunities, he happened to be in a store. He was great. He actually came and went to a second store with us to talk about some of the things that we were seeing. So only Brandon.
Okay, and that was just Brandon was in the store for doing an inspection, and you happened to be there?
Yep.
Okay.
Yes, ma'am.
Just for the record, I didn't mean to interrupt, but could we just say who Brandon is?
Brandon Holland,
Inspector.
right back there. He's there, another inspector, for the record.
Right.
He was
Thank you.
great, by the way.
Holland. L-O-A-N-D. I think that's all I have. Thank you.
Thank you, Ms. Fales.
That's right. Any follow-up?
I will turn it over to the board. Nothing further from me.
Board members, any questions? Everybody seems Dr. Russ?
Do you know the pharmacy tech ratio in your stores?
So I'll say this. I'm glad you asked. The reason why Ashley was Dr. Ellis, excuse me, wouldn't tell you definitively. It varies based on time of day. You can walk in a store and we'll have a 4-hour period where there'll be potentially 3 techs. She described later on in the evening, it may be 2 techs. It's based on needs of the business. Typically, from a scheduling perspective, stores have the biggest workload first thing in the morning. This also is a root cause of if a store gets behind. We will have the appropriate staff in a store, but if the pharmacist doesn't schedule them when the business needs call for them, they could get behind in their work. So it varies store to store.
So what would you say it is now?
It varies depending on day. You may see 3 to 1, you may see 2 to 1. Volume wise, there's no need for 3 techs in a store if the volume of prescription isn't there.
Do you have any stores in which it's just a pharmacist and a cashier filling 500 scripts a day?
Not on purpose. No, sir. That would be either call outs, if there was an issue.
So
and then
it's safe to say you don't know.
it wouldn't be on purpose.
So
Not that
yes
I
or
know
no?
of. No. Okay.
You don't know. No. Okay. Thank you.
There's been a lot of talk about adequate staffing. So your system can tell when you're overstaffed? Yes or no?
It gives guidelines, yes.
How do you tell if you're understaffed?
Well, so the methodology we use for the budgeting takes into account so many things. I don't even know all, I couldn't rattle off everything. It's drive-through, it's waiters, it's acutes. It may be vaccinations done in a store. It could be third-party issues. So it takes into account all these different things that go on per store, and it gives a level of demand, tech demand for that store.
Okay, so you've got how many stores under your purview?
234 currently.
How many of those 234 stores, how long have you had those stores?
Since the beginning of 2023. Now, we actually, you may have seen in the news, we reduced some store counts, closures, just because we had too many stores and pockets.
Okay, well, let me ask a different way then. Since 2020, have you been in the same role since at least 2020? Different districts, but you've been in the same.
I've been a regional director for going on 7 years now.
Okay, how many times have you added pharmacist staff? How many stores would you say approximately ballpark where you've found that you've been understaffed and you've either added at least one FTE or a half FTE pharmacist or a half FTE or one FTE tech since 2020?
Since 2020? God, I probably couldn't tell you an amount. This is what I can say. We have stores that have growth occur. Our system looks at trends 5 weeks and 6 weeks. It may not catch up as quickly as it needs to. We email workforce management and let them know, look at the volume, look at where we are. This is what we need to meet the needs of the business. I do have the privilege, I'd say, or ability to make sure we have what teams need to meet the needs of the business. So yes, I've added pharmacist hours if it were necessary and tech labor based on trends of similar stores. If they're exceeding their budget by 30%, hey, do we have needs? I'll also do want to make this statement. We talked about staffing. In most of the stores throughout my time period, adding labor does not fix root cause in a store if it's broken. What fixes root cause in a store is proper training. Everyone here talked about the level of proficiency from a technician, right person, right place, right time. So you can go into a store, if you see different things going on, it's not first and foremost staffing, it's the leadership in that store, and are they trained properly to do their job? Because we have those other stores that do deliver under those same exact circumstances.
I don't disagree with that from the standpoint of you either have not the right skill mix or you could have not the right competencies in place. But as it relates to workload and potential medication errors, would you agree or disagree that staffing can play a role in the ability to have enough time to do your due diligence to try to prevent errors from happening?
It's a factor. It can, let's be transparent on us, it can provide additional stress on teams. We are able to go back pretty consistently and identify a step that was skipped in the workflow process that led to that error. So it's, once again, it'll go back to training.
Are you from, well, I'm not gonna go down that rabbit hole.
Thank you.
So are you telling me that y'all have a training protocol for a single pharmacist and a cashier to fill 500 scripts in an 8-hour period?
We don't have a pharmacy that's filling 500 scripts a day with one cashier. If that has occurred, there's something that went on in error. They're not budgeted for that, if that makes sense. It was either a call out in 2020, COVID, we talked about it. One person didn't just get sick in the pharmacy. It was everyone.
Training is important.
Very.
I'm not discounting the needs of training. I will just say, if you look at the nuclear power plant industry, for example, and the airline industry, it's systems issues that they focus on. It's not necessarily training. It's, do you have the systems and the processes built to support a safe environment, and staffing is part of that. That's my point. Look at root cause analysis and the steps that you can take to try to actually training and developing policies and procedures is one of the least effective things that you can do compared to systems fixes. So I guess that's my point. You can double check me on that. If you want to look at just culture and, those industries and how they approach prevention of errors, I think you'll find that that's the case. So.
Richmond?
So I'm not going to attempt to relist the things, but you listed a number of things that go into factoring staffing. You said number of immunizations, drive-through, walk-ups, all those things, right? And did I understand that you use that trend data to then establish what your needs are, your staffing needs?
I don't. Corporately, it's built into the system.
When I
So
say you, I'm
Okay.
talking, frankly, I'm talking about the stores at Bellevue and Texarkana and Sherwood, but those folks aren't here, you are. So I'm asking from whoever sets that for the store level, that based on that information, which presumably comes from the individual store level, that based on trend data, then staffing patterns are established. Is that right?
correct.
Okay. So if you're establishing it based on trends, then your staff is not scheduled on a day-to-day, hour-to-hour basis, depending on what that trend is. I mean, would that be correct? Or would it be generally for a week's period of time?
You can pull up in our stores, it's by minutes, 10 minutes, 15-minute increments. It'll show where staffing and labor should be.
So if you have a store that fills whatever number of prescriptions per week, so on Monday at 1:15, somebody walks out the door, but on Tuesday at 12:30, you have more people walk in I mean, is it down that specific?
I don't care. What do you mean more people walk in?
I guess what I'm trying to get at is it would seem to me that if you're basing your staffing based on trends across a week and maybe even on a per day basis in terms of our busiest day of the week is a Monday. I mean, do you then staff accordingly based on the same way that you trended that data? I mean, you're not calling people in as trends spike on an hour-to-hour basis. Is that right? I mean, how often do your staffing trends change?
Here, it's by week and daily. You just heard Ashley state now, we know they're shutting down 5 Walgreens within Arkansas. They posted that. Our stores are busy. So that changed within a week's time. So it's different factors that will occur.
So you're
Here's
saying
what
that they made their decision to close those stores based on from one week to the next decision?
Oh, I have no idea. I don't work for Walgreens. I'm just saying what was announced.
Right, that's my point, is that there is a trend and you use that trend to establish, okay, in this store, I'm gonna have 2 pharmacists with 3-hour overlap. They're gonna work 12-hour shifts. And I'm gonna send in 2 techs per shift or whatever. I mean, you do that based on trends. You're not trying to read your staffing and send people in there on an hour-by-hour basis.
The attention we have placed on work carrying over, the district leaders look at what's going on in stores. Managers have a responsibility as well to notify them, hey, if I'm getting behind, what's going on? Once again, we go back to identify root cause. We have the latitude to send additional support if needed, if the business needs call for it. I don't know if I answered your question.
I'll let it go. Like Dr. Dolly said, I'll quit going down that hole because I don't seem to be getting a direct answer from anybody on this. You mentioned something, a 90 per 1 or 90 per 3. I didn't understand what that was. Tell me what that is.
So with tracking scripts, 90 as 3, you feel the insurance will pay for a 90-day supply. We can either count that as 3 scripts because it's 3 30-day scripts or as 1. It's really 90 as 1 because the team filled it once. So that's the breakdown. Our scripts are tracked. Don't even ask me why. I wouldn't tell you why per se. That's probably based on billing and other things, but it's 90 is 3. We have data on how many scripts the store does. We also have data on 90 is 1. 90 is 1 is the true number of scripts filled. Did I do a better job?
Yes, thank you.
Thank you, Doctor.
Would you agree with the statement that having systems in place versus those systems actually being followed as intended, they're not necessarily the same thing?
Repeat it one more time.
Okay, having a system in place, whatever it is, whether it's staffing or whatever, that having a system and this is what we're going to do versus that actually being followed are not necessarily the same thing.
Yeah, they're not the same thing.
Okay. Thank you.
I've been quiet so far because I've been waiting to hear some response from CVS to the specific order and notice of hearing in these 3 cases. I haven't heard any of that. Now, I assume you're the highest ranking CVS official here, so I assume you're speaking for CVS, right? You're in effect the corporate representative in this hearing, right?
I consider myself local as well. I'm the local representative. I'm a director.
But you're representing CVS,
Yes,
right?
sir.
What you say is speaking for CVS,
Yes, sir.
right? Right?
Yes, sir.
Not just for you, but for CVS.
For CVS.
Now, there's been a lot of discussion all through this about understaffing, and we've gone in all kinds of directions about what understaffing is and isn't. And I want to focus on what the actual allegations say about understaffing. Each of the 3 orders state the respondent pharmacy was not adequately staffed during the period of this prescription investigation. Are you familiar with that? That's the
Yes, sir.
allegation in the order and notice of hearing.
Yes, sir.
Do you have any facts to refute that allegation?
I think those facts were presented by counsel over the last 2 days.
Council's not presenting facts. You're the representative. What facts do you on behalf of CVS have to refute those allegations?
I think my answer will remain the same.
I'm sorry.
My answer will remain the same. Those facts,
What are they? Tell us what those facts are.
you want me to go back through that full testimony?
I
Then
want-
and then
I want you to
Can I
tell me
finish?
what facts you have to say that the respondent pharmacy was in fact adequately staffed during the period of the prescription investigation.
Your Honor, I object to the extent this is suggesting that the burden of proof here is on CVS, not the board. CVS doesn't have to prove anything.
I understand it. I certainly agree with it. I just want to know what facts you have, if any, that refute that allegation.
Dr. Simpson, I wasn't enrolled in 2020. I hadn't been in those stores
You
either.
have no facts to refute that allegation.
Facts are, we talked about that it wasn't solely staffing that was an issue. We gave descriptions on what could have caused that snapshot in time when the board inspectors went into the stores.
I hear a lot of obfuscation. What I want to know is whether or not, yes or no, you have facts to refute that allegation in the notice of hearing.
Your Honor, I've got to object to ask and answer at this point. I think he's answered it as best he can. It may not satisfy Dr. Simpson, but I got to protect my witness at some point here.
It's been answered, it's been asked and obfuscated.
Well, I don't think you're going to get an answer that's sufficient to meet what you're looking for. And so I'm going to ask you to move on. Yep. All right.
Okay, with regard to the charges, do you have any facts that would refute the charges that are set forth C1 through C4 and in the 1C5?
My answer wouldn't change from the previous question. That's
So you
the
don't
same
have, you
question.
don't have any facts to refute it.
You have come forward and presented the data and the information based on these cases over the last 2
Well,
days.
could you just, I'm not a pharmacist, so I'm perhaps approaching this very simplistic. But could you just briefly outline what the facts are that CVS has that refute the charges set forth in the notice period.
Your Honor, I've got to renew my objection. I'd be happy to address this. We'll address it in closing argument, but
I think it's going to be an issue for Columbus.
I'm
Primarily.
I'm asking for facts that can only be presented by the witness. They can't be presented by the attorney.
Well, and I understand I understand your frustration. You're not getting it from the witness. But in terms of a charge, that's basically a legal conclusion. And they're here to provide you information, background.
That's fine. And if he has none, all he has to do is say, I don't have any facts to refute that.
I don't know if he's going to get to that point.
I wouldn't make
yeah,
that
I
statement.
still object.
I'll make one statement.
Sure, go ahead.
Okay, we looked at the charges. We looked at Dr. Kirkley stated earlier in his statement, we're not talking about staffing. We're talking about error rate. When you look across all the audits that were done, CVS had a lower error rate than the other parties.
I'm gonna object at this point. I think that's a mischaracterization of Dr. Kirtley's testimony.
Everybody's objecting to everybody
Yeah,
else.
That's, I think I've made my point.
All right. I got a bunch of hands. Who wants to go first?
I just want to ask, can I ask a question of either witness or just,
You can ask a question of either witness. They've both been sworn
are
in.
either of y'all employed or have either of y'all ever been in the Texarkana store?
No,
Were either of y'all
Rellis?
employed
Oh, okay.
during the,
I was employed. I hadn't been in the Texarkana store.
Bella Vista, Sherwood,
Yes, I've been in the Bella Vista and
when all this was
Sherwood store.
going on?
No, sir. I picked up Arkansas in January.
So neither one of y'all really were involved in any of those stores when all this was going
During
on?
2020.
Thank you.
Dr. Richmond.
So I want to go back and make sure that I have a list of the corrective actions that have been taken by CVS, and I had made notes. And I think that this was outlined in, who's the person named Rowe?
Professional practice leader.
Okay, so is that a Mr. Dr. Rowe?
Dr. Ruff, he's a
Dr.
pharmacist,
Rowe,
yes,
okay.
sir.
So in the transcript that was created from Dr. Rowe's appearance at the informal hearing in 2021, so it's my understanding, as was outlined, that there were identified incomplete SIGs were identified as an opportunity and need for correction. That then there were statewide so one, they identified that as a problem. So that's one thing. Two, then there were statewide conference calls that were held regarding that pharmacists, it's my understanding that bench level pharmacists would call in and participate in those calls. Is that right? Okay,
That's what I read. I wasn't privy to it.
okay. Well,
I wasn't,
Ms.
she
Ellis-
wasn't enrolled either.
Okay. Well, I'm just trying to get a general understanding. Three, then, that was developed, I'm not sure what this means, but anyway, it was an exercise of some kind. That was a hub portal-based exercise that was completed by bench level pharmacists. And then Dr. Rowe visited stores. So those are four things that have been identified as corrective actions. My question, and it can be for either one of you who knows, is what additional, if anything, was done in a corrective way in response to the findings in the inspections that are central to the case?
I would be privy to that because it's.
Okay, then you can answer the question. How about Dr. Ellis?
She's not before the board right now, but I'll tell you, she wasn't part of that either. She's not gonna be able to answer it. I'll just venture that.
So
I think
nobody can give me anything other than those four things that have been done.
I would point you to Dr. Rowe testified. I think there's 20
Dr. Who, I'm sorry.
Rowe testified. There's 20 pages or so of his testimony that was really
Okay, and-
detailed. He was the hands-on person that did those things. So
And
I think
these four things were highlighted in testimony today from Dr. Rowe's testimony. So if Dr. Rowe's the expert that handled that, we've got four things that were done as a corrective action.
I can't testify. I'll just say that it's in the record. There's 20, 30 pages of it. Those are 4 things that were highlighted from those 20 or 30 pages, but I can't testify for you.
Right.
And can I add, that was not testimony of Roe, that's informal. No one was sworn in that day.
Okay, so from the transcript, at the informal, that's where that came from. Now, I don't know, can I ask a question of,
Sure.
I mean, can, Dr. Kirtley, can you characterize anything that you recall having been done that was provided comment by Dr. Rowe in that transcript?
Are we calling Dr. Kirtley back here? Are we finished with, man, I know this is, we're trying to get to the bottom of it, but this is a Administrative Procedure Act proceeding, so I've got to
I
object.
understand, and I think it's almost like they're gravitating into the deliberations before they get there.
I intend to
Um,
call Dr. Kirtley
Yeah.
as
Well,
recall.
I don't want to get, again, a form over substance here. I understand your objection and I understand your concern. I do. But Dr. Kirtley's been sworn. He's here. There's a question from the board. And if you need to call whoever you need to do or do another question, whatever you need to do in order to make your point, Mr. Mitchell, you know I'm going to allow you to do that. All right, Dr. Richmond, do you have a question for Dr. Kirtley?
So the question is other than the 4 things that have previously been identified just a couple moments ago, and having established that neither of the CVS folks here who can testify can supplement that answer to change it, seeking anybody else who has knowledge of that, we'll call it a transcript, of whatever it was. Is there anything else in there that I'm missing? Because I don't recall, do we have access to this on our?
Yes,
Okay,
sir.
Can you point me to the tab? I'll be happy to read it
Exhibit
myself.
60, the entire transcript from the
60,
informal
okay,
hearing,
all
so
right.
it's in there.
But summary wise, can you supplement that in a meaningful way?
I'm not aware of anything else that would be meaningful other than what we went over earlier in testimony. That was what happened in that discussion. As Ms. Bales pointed out, we weren't sworn during that. I can't speak to the accuracy of it.
Mr. Hearing Officer, I'm confused. Can we rely on what's in that transcript as evidence?
It's in the record.
It may, but it's hearsay. If it's hearsay, what he said, and he's not available to testify.
I understand it's hearsay, but it's part of the record, and hearsay is completely admissible in an administrative hearing. It's allowable. We've heard reams of hearsay throughout the last 2 days.
I think it
But I will
goes,
say this, we'll all hearsay. It's up to the board to give it the weight that the board and the individual board members believe it deserves. That's how you have to roll with hearsay in an administrative hearing. If this was a circuit court proceeding, I would exclude all hearsay, but it's not. It's administrative and it's allowable. Heck, most administrative records, and 90% of them are hearsay. Dr. Richmond, do you have some additional questions?
No, sir. I
I'm
don't.
sorry.
Thank you.
Any other board members have questions?
Before we go off the record, I just want to make sure that before we start deliberations, to prevent having to come back on the record and ask this, the scope of what we're going to discuss is those 3 orders of notice of hearings for those 3 stores, correct? There's no
I can,
pharmacists involved here. It's all the stores, the permit holders that we're talking about.
I'll address that in my closing, but yeah,
Okay.
you're correct.
All right. Speaking of which, Mr. Mitchell, before we,
I had one, I wanted to try to clarify something with Dr. Powell, and I think there was just some miscommunication on some of the questions, particularly about the Walgreens closing and trends and what that means, that I thought you two were speaking just different things. So I want to try to clarify that. But so Dr. Richmond was asking you about looking at trends and CVS looking at trends to determine how hours need to be allocated. And you mentioned that, yes, it's not just looking back at a year, but something like 5 Walgreens stores closing, that CVS can react quickly in real time to respond to that and adjust. And I just want you to elaborate on that because I felt like his question, that your answer maybe, he felt like didn't address the question.
Okay. We have the ability to adjust in real time. It may take it longer from a systems perspective for it to show up in the actual, what our teams see at my schedule level at the store. But we have the wherewithal. We can adjust immediately when we need to.
So it's not just looking at a year over year trend.
It's not.
That's all.
Anything else from anyone else? If not, closing statements?
I'd like to recall Dr. Kirtley briefly before I get
Okay.
to closing.
All right, please proceed.
Dr. Kirtley, as part of the board's deliberation, if they see fit to, are there any administrative costs that you would like to be considered with regard to this case?
Yes, in general, one of the reasons why we do informal conferences is we can do those with much less preparation or work on both staff and whoever is in front of the board, being an informal process. Whereas the amount of time it may take to initially look at prescriptions is one thing in a case like this. Preparing for full hearing with all of the evidence, preparing for testimony, preparing books and everything else is a tremendous burden on board staff. When we looked at this and discussed with our staff and previous staff, we would figure that, our inspectors, namely Dr. Fain, would probably have somewhere in the tune of 200 hours invested in this case prior to 2 days of hearings potentially. I can tell you that I easily have another, 60 hours in this case myself. Dr. McCready, in talking to her, estimated that she had a minimum of 80. I believe our attorneys would probably have 240 hours in this case. When you also talk about the cost of having hearings, we've set forth a 2-day board hearing just for this matter. This is the only thing we've done at this hearing, other than approving our travel documents, which took mere minutes. Just the cost of all that, if you extrapolate it without fringe benefits of staff, just straight salary, you're talking something in the tune of, $45,000 of investment just to bring this to hearing.
Thank you.
May I cross-examine?
Sure.
Couple of questions there, Dr. Kirtley. So, from the time that Dr. Fain performed her last inspection that we saw in this, that's related to this proceeding, that was in 2020, correct?
That's correct.
Now, Dr. Fain has not, in terms of preparing for this, done anything else, has she?
Yes, she has.
Well, Dr. Fain isn't even an employee of Florida Pharmacy anymore, is she?
No, she
And-
left a few months back, but she was an employee into 2023 as we prepared to have this hearing when we try to notice it up for June and then again for October.
Okay, and those notices were issued about 2 weeks before for a 2-hour hearing.
I don't recall it being for a 2-hour hearing.
Okay, so Dr. Fain left, I think it was July of 2023.
That's correct.
And in terms of out-of-pocket costs of the board, did the board incur out-of-pocket? I understand that there's staff for the board that are paid to do as you and Dr. McCready direct. Did the board have to incur anything above the ordinary salaries of you and the other board members?
Yes.
And what was that?
Any type of travel that we would do for an on-site, either inspection, audit, retrieving, returning materials, as well as for the board members to all travel here for this hearing, to put them up, meals, the out-of-pocket expenses of preparation of, basically board data, paying for witness travel. Now that Dr. Fain no longer works here, I did not even take that into account that, we do have the need to pay her as a witness subpoenaed here to come and testify as well. So it's, yes, out of pocket, but also carving out time for this case that could have been spent on other activities in the office.
But board inspections, there hadn't been any board inspections since 2020, right? Related to this.
Not necessarily for this case, but these stores have been inspected again. I'm not counting cost of normal inspection schedule.
And when these stores were inspected again, other than the one single incident where the inspector needed to come back 2 weeks later, they all passed all the inspections, right?
Yes.
And do you think it is a deterrence for anyone that appears before this board to assess additional fees for exercising the right to appear before the board?
I believe someone could identify that as a barrier, yes. But I think it's that for any type of case or hearing. I think they would identify that as a potential issue, but I think they could identify that as a potential issue for any case or hearing.
Nothing further.
Ms. Rails? Board members?
So would we essentially consider that to be user fees, if you will?
We would call it investigative cost.
But I mean, us appearing here,
That would be part of the cost of putting on a hearing.
okay. All right.
Yeah, this is a specially called board meeting only for this issue. We would generally not have incurred any of the costs today had we not had need and request for a 2-day hearing.
Anyone else? Anything else from council? Rebuttal done, Ms. Rails? Okay. How about closing statements now?
And I'm not going to belabor this any further, but I do want to turn back to the order of notice of hearings that you'll have to deliberate on and make findings on. As you heard Dr. Kirtley testify, we charged this in a way that gave you as decision makers a little bit of leeway. So we charged CVS under two sections, section 311, which is alternative penalties. And that's in your law book if you want to refer to it. Are we good?
You're gonna go through all three of the board.
Yeah. And it's the same for all three. We charge them under chapter 300, which gives you the opportunity to do alternative penalties. If you deem this case worthy of any kind of discipline, you have that option. Could have solely charged them under section 407. That is also in the order and notice of hearing on these cases. That would require, if you made a finding, to simply revoke the license or the permit of the CVS pharmacies. We didn't go down that route. We could have. We didn't go down that route. We gave you that option. So you can look at section 300 for your options as well. With regard to the last 2 days and discussion of Anderson's and Walgreens and how the board treated them in this case and that case, I think you heard from Dr. Kirtley that those different audits were done based on what store they were in. It's not necessarily, we didn't do a market analysis to see the error rates of various types of pharmacies in the state of Arkansas. Dr. Fain testified she went in and was able to obtain what she had. If Anderson's records had electronic copies in their California files, she looked at that. She didn't ignore that. She didn't do these here. These audits were done with respect to those different cases. And so there's been a lot made mostly by counsel of disparate treatment by the board in their informal decisions with regard to Anderson's and Walgreens and CVS. And I think the idea was in their minds that you had to treat everybody the same. That's simply not supported by the law. You look at the informal process, the informal hearing process, those are negotiations. They're not on the record. We present what we have as board staff, they present what they want, and you all decide what you think is appropriate, and they can take it or leave it. In this case, CVS left it. The other pharmacies, the other pharmacists that were involved in the errors, that were complaints to the board, they took your offer from the consent agreement. Those cases are done. You had other pharmacists that had error rates of 10 or fewer errors. The board made a suggestion with the informal process with those. They agreed to that. It was some CE. Those cases are done. We're looking at the responsibility of CVS pharmacies. So that's all that you have on the table before you today. The disparate treatment was revolved around the informal process. That is not appropriate at this point. CVS is the only one here. They're the only ones between Anderson's and Walgreens that took it to a formal hearing. There's no precedential value with regard to the treatment of the dispositions and the treatment of Anderson's and Walgreens. So I want to make that clear. And your decision-making, again, I'm going to return to the law. As this hearing is conducted under 2515-212, which, or the Administrative Procedures Act, specifically 2515-212, which is in the board law book on page 143, if you want to look at it. That is the standard for judicial review. That gives you guidance as a board member of what, if you make a decision, it will be upheld judicially if there's 4 things, if it contains 5 things, 6 things. So your decisions have to be, they cannot be in violation of, I need better vision, constitutional or statutory provisions. That tells you you have to follow the law and you can't do anything unconstitutional. You can't do, number 2, if you look at that statute, can't do anything in excess of the agency's statutory authority. And we have some statutory authority with the alternative sanctions. There's a stopgap as far as monetary fines. I think Dr. Curley testified, you heard him testify, that's $1,000 per violation. The third provision is you can't make a decision upon unlawful procedure. And I'll submit that we've not done that here today, due process, and thanks to our hearing officer, we've been provided that through that. You can't have, your decision today can't be affected by an error law. It can't not be supported by substantial evidence of record. And it cannot be arbitrary or capricious. Arbitrary and capricious is terms of art. Basically, it's telling you, you can't make a decision on a personal whim. You can't make a decision impulsively. You have to listen to the evidence that's presented in front of you. You have to deliberate and make a thoughtful decision. And I know you all are going to do that today. Those are your guidelines about how you make a decision in this case at this level. This is not binding when you're at the informal process. So the disparate treatment is an argument that I would submit to you is not applicable in this case. When you look at what's been presented over the last 2 days, well, let me start this. This case, as you're well aware, some of you that have been here for a while, this case has been continued years. This happened in 2020. So to look at this and evaluate what's been presented to you today, you have to go back to 2020. That's when these audits were done. That's when the evidence was gathered and prepared. Now, this case was continued partly because the board didn't have an attorney for a while. Mr. Mitchell has asked for continuances. So I can't go back and tell you why we got here 3 years later. But I submit to you that CVS shouldn't get the benefit of this delay. We're not asking for any benefit of the delay. And we have testimony from witnesses that can't testify to what happened in 2020. So give whatever weight you would like to their testimony, but it has nothing to do with what happened back in 2020. They can't speak to that. So we're asking a lot for you to go back in time. But the best evidence you have in front of you the only witness that could really tell you what was going on in 2020, truthfully, is Dr. Karina Smith. And I hope you found her testimony credible. Her time at CVS is well in her rearview mirror. She's worked other places. She's got her career on a completely different path, but she felt compelled to come back here and discuss with you the workflow and conditions that she had in the CVS store in 2020. So I hope you give that the appropriate weight when you deliberate, because really I think that speaks volumes as to what was going on back in that time frame, and that's really what you have to look at. The error rates, ideally an error rate would be, an only acceptable error rate is probably 0. I don't know if that's realistic or not, but the errors that we saw that Dr. Fain testified to were the same errors that were occurring over several different stores, over several different pharmacists. That seems to me, and I would submit to you, if you look at that, that seems to be a problem for CVS. They need to go and look at that situation and figure out why that was happening and what is wrong. And we don't have that testimony really that occurred today. Nobody can tell you that. We had some statements from someone at the informal. You can go back if you were on that informal committee and determine if any of that holds any weight. You heard Dr. Kirtley testify. It didn't hold any weight with him. So I submit that to you. I think the errors, you know, there are errors that didn't go out to the patients, and there was not patient harm in all of them. There was only patient harm, I would submit, in 2 of them, but there could have been. And if there was patient harm on those errors for, say, someone that put their fentanyl patch on too many times because their label didn't say that, that could have been severe harm to a patient. And only by the grace of God, that didn't happen. But these errors need to be, that CVS needs to be accountable for the errors, because either staffing or inappropriate training or not enough technicians, that's all within their purview to control, and not the pharmacist working the counter. So at the end, when you deliberate, whatever you decide, I just ask that you give the appropriate weight to the evidence that you have in front of you, the best evidence being Karina Smith. And I think if you do that, you'll find that disciplinary action needs to be taken, and CVS needs to be held responsible for these errors that we've identified, including the misbranding, including the 2 pseudoephedrine transactions, including those med errors that resulted in complaints. This is a systematic problem, and you can only hold at this point CVS responsible as a whole. I think that's appropriate to do in this matter.
Thank you, Ms. Vales. Mr. Mitchell?
Yes, thank you. And thank you, board, for the attention over the last 2 days. I know this is not where anyone wants to spend a Tuesday and Wednesday, but we do, and my client does appreciate the opportunity to appear before you and address these issues. So as I said at the very beginning of this case, very beginning of this hearing, is that CVS is not here to say that these 3 stores made no errors in the time frame charged in the 2020 period for each of the 3 stores. Dr. Fain conducted inspections and identified errors. Again, that is not in dispute. What is in dispute, though, and at risk of stating the obvious, is whether CVS store 1019, 10430, and 10408 were adequately staffed, again, at the relevant time period, as they are charged with in the notice of hearings. What also is in dispute is whether these 3 stores or any of these 3 stores violated the specific statutes that they have been charged with violating. And then last, but certainly not least, is whether there is any sufficient basis in fact, in evidence to treat CVS differently than the board treated Walgreens or Anderson's, arising from audits conducted at or about the same time period as CVS, and conduct, I think that has been more or less undisputed that the errors were more or less of the same variety. Although we have certainly pointed out that the other stores had higher error rates. I want to note for the board that although these 3 cases were consolidated for efficiency purposes, these are 3 different cases. And I submit to you, board members, that in considering the charges, that the board must consider each store independently and the evidence with respect to each store independently. It's 3 different cases. And finally, this came out, but it is very important to note that the board has the burden of proof. The board staff has the burden of proof. CVS does not have to prove anything. We could have sat here and my client was not required to put on any evidence, put on any testimony whatsoever. Rather, the board has to prove beyond a reasonable doubt, excuse me, not beyond a reasonable doubt. I wish.
Sorry, Mr.
By a preponderance of the evidence that the allegations and the specific statutes that were violated, not that you may believe from some previous perception, but there is evidence before you. There was evidence presented before you in this hearing to demonstrate by a preponderance of the evidence that those violations occurred in the relevant time period, which is identified in the notices and charging orders. And specifically, they're identified as during the period of the prescription investigation for each of these 3 stores. I submit to you that the answer to that question is no for all 3 stores. So I want to talk about each store briefly and talk about the evidence that was presented with respect to each store. So first, Sherwood, 10-430. Now, Dr. Fain is the only person that testified or presented any evidence before you about Sherwood. Dr. Kirtley admitted he hadn't been to the store. He didn't conduct the inspection. Dr. Fain told us, if you recall, at first in her direct exam, she said she didn't even conduct an inspection. She just showed up to pull prescriptions and left in order to go do an accuracy audit. But then in cross-examination, I actually showed her her inspection report from that day. And as Ms. Vales pointed out, yes, it has been some time. But as Dr. Kirtley just pointed out, they have spent hundreds of hours preparing for this. And that is a basic fact that is in question, and it's an inconsistency, frankly, in the board's presentation. She did complete an inspection report. That inspection report from that day when she was in that store is the best evidence before this board about what was going on in that store. The store passed the inspection. There is no mention in that inspection report of inadequate staffing, of the store being backlogged, of pharmacists in that store complaining, nothing. That's the evidence before the board about this store. So when you go back and deliberate and you ask the question, okay, what evidence is there about Sherwood 10-430 that, as it's been charged, that it was not adequately staffed during the period of this prescription investigation, and that inadequate staffing contributed to the errors that occurred? I submit to you that there is zero evidence before the board to support that charge. And for that reason, the charges against 10-430 should be dismissed. Now, she did conduct an accuracy audit for 10-430, and that is an evidence. And her audit revealed, Dr. Fain's audit revealed a 5.5% error rate. Many of the errors were, as we heard, just like with Walgreens, leaving off PRN or something like that, but there were some other errors too. We don't deny that. Now, the board staff has tried to say, well, one thing you can look at to determine or maybe sort of read into, assume whether there's some sort of systemic problem or it's an isolated issue with one pharmacist or not, is whether the errors are spread evenly across everybody. You know, everybody there is making an error. 10-430, we don't have that. There were 2 pharmacists that identified errors, Dr. Charles Johnson and Dr. Demario Rollins. Dr. Mario Rollins had 3 errors out of everything that was identified. Maybe the lowest error percentage or error rate of anybody that this board has heard testimony about. Dr. Charles Johnson did have a lot of errors. He had 27 errors. We also heard about the patient complaint with Dr. Charles Johnson. Dr. Johnson failed. Was that serious? Absolutely. Dr. Johnson failed to report that, and he was terminated by CVS as a result of his failure to report it. Again, though, is that evidence sufficient to establish by preponderance of the evidence that store 10430 was inadequately staffed and that inadequate staffing led to the violations? Submit the answer is clearly no. Turning to Bella Vista, 10408. Dr. Fain, this was the one store that Dr. Fain testified she actually did spend a little time in. And Dr. Fain testified that the store was busy. When she was there, there was a new pharmacist that was there, and the store was working to fill 2 open tech positions. Not that CVS didn't allocate hours or allocate money for those positions, but there were openings at that time. We heard some testimony about COVID. I'm not going to go into COVID. COVID affected everybody, but it did present challenges. I think that has to be taken into consideration when you're considering whether or not there may be an open position, particularly in a customer-facing retail type position. In that store, there was an audit and there was an 8.2% error rate. That wasn't great. CVS, I think Dr. Ellis or Dr. Council would tell you, we have some things we need to work on there, certainly. We need to do training. We need to get those tech positions filled. And thank goodness we've got good folks like Dr. Ellis now as the leader for that area and has those positions filled, has all the pharmacy positions filled, and is working on filling tech positions, which, as she said, in a retirement type community like Bella Vista is not the easiest thing to do. That's all the evidence, though, about Bella Vista. Basically, Dr. Fain there for a couple hours. It was busy. It was a bad day. They were short 2 techs, and there was an 8.2% error rate. That's it. Texarkana, 1019. So Dr. Fain again, well, this one, there was even more confusion. So Dr. Fain testified, and then Dr. Kirtley testified the same thing, that this audit occurred, the accuracy audit in Texarkana occurred because of a patient complaint. We looked, though, both yesterday with Dr. Fain and again today with Dr. Kirtley. The patient complaint was made on August 31st, 2020. That store was audited by Dr. Fain and prescriptions were pulled on June 22nd, 2020. Now, the board attorney at one point said, yeah, but maybe they would have called earlier. But we also know that wasn't the case because Dr. Kirtley testified, as shown in that report, the patient didn't even realize the error until July 8th, 2020. So even if accepting their explanation is true, that the patient called the board before submitting the report on August 31st, 2020, the patient didn't know until July 8th, 2020. And I think even Dr. Kirtley had to admit, as well as Dr. Fain, that they're just not sure how to explain that. An accuracy audit's conducted because of a patient complaint, but the patient complaint's 3 months later. It just doesn't make sense. But Dr. Fain testified, again, she spent 0 time in that store. She walked in, grabbed the prescriptions, walked out. I then showed her her inspection report, which maybe suggests she did spend a little time there because she noted a few things that are pretty particular. And that's in the record, you can see. She noted that the temperature in the store was a little bit high. The temperature when she was there was 76 degrees. That's in her inspection report. She put details there. There's no details about staffing, no comments from her about the store being backed up, anything else. From her recollection, she walked in and walked out. So then what does that leave in terms of evidence that this board has heard about inadequate staffing in store 1019? Dr. Karina Smith, that's it. And as Ms. Vale said, she thinks that's the strongest evidence. We would completely disagree. So for starters, the time frame is important because regardless of what you think about credibility or not, Dr. Smith was in the store, worked there for 2 years approximately as an overnight pharmacist with one exception. And that exception was a 2-month period in late 2019 where she subbed, if you will, for the daytime pharmacist because she was out on maternity leave. That was Dr. Brita Aid, who this board heard from at the informal hearing. 2 months in from October, November, December, call it 2019, Dr. Smith was in there during the day. That's it. Now, she testified a lot about how busy she was, about how this was. I mean, as I heard, I was like, goodness, who would ever work in a place that sounds like that? She worked there for 2 years. Since then, she's had 4 or 5 different jobs, never staying anywhere more than 6 months. That's evidence. Also, given her testimony about the working conditions there, she told us about the PIC, Dr. Brita Aid. I don't remember the exact word she used. Maybe goddess was a word, but said she was unbelievable. One of the best pharmacists she'd been around. She cared about her patients. She did the right thing. Dr. Brita Aid is still the pick in that store today. There's questions about turnovers, and I think an assumption that no one stays at CVS. Dr. Brita Aid has been the pick in that store, still is today. Dr. Demario Rollins, who we were just talking about in Sherwood, he is still the pharmacist, the staff pharmacist in Sherwood. People don't just fly out of CVS every 6 months. That's not the situation, and there's certainly no facts in the record to submit that. And she testified Dr. Brita Aid was a great pharmacist. Yet, that place was terrible. It was so terrible she couldn't keep up with anything, but she had time in November of 2020. That's when all her pictures are from, November of 2020, not when she was filling in during the day, but while she's an overnight pharmacist, she had time to start on her own going around and auditing what everybody else was doing. I haven't seen that audit report. I don't think anybody here has seen. I hesitate to call it an audit report. Whatever she was doing, nobody's seen it. Now, she told us about it, that she was finding errors. I'll submit to you at that time, she was only there at night. It's undisputed. She was the overnight pharmacist. So what can she testify to about during the day? And she told her district manager, she said, about the errors. Did CVS say, no, don't do that? What are you doing? Why are you doing that? No, she testified CVS encourages its pharmacists to report errors. And CVS told her, keep that, put that in the store, make binders, start telling people about it. That's what she testified that her district manager, Neelay, did in response to that. And this is a person who admitted, frankly, she has an axe to grind against CVS. She left CVS because she wanted to become a daytime pharmacist at a different CVS store, and that transfer wasn't approved. That's what she testified as to why she left. So when you put all this together, frankly, I submit that Dr. Karina Smith's testimony, number one, it's a wrong time frame. It's October, November, December 2019. That is not the time frame of the prescription investigation during which CVS is alleged to be inadequately staffed. But two, there's a major credibility question there with her. Dr. Brita Aid's testimony, it's in the record. She testified at the informal hearing. She's the pick. She's still there. She told this board at the informal hearing, sure, there are issues, particularly in June of 2020. That was ground zero with COVID. Nobody even knew what COVID was at that point, other than it was going to kill us all. That's when they were inspected. I think the board needs to keep that in mind. And I'd submit there's not evidence in the record for the board to conclude that CVS was inadequately staffed from May to June in 2020, which is the charging period, or that it violated any of the statutes at issue. And finally, I don't think I mentioned this, despite what Karina Smith said about how terrible this place was, it was a 5.5% error rate in the audit. That's the data. Is 5.5% great? No. They would tell you they want that to be better. They think it is better now. 5.5% though is not 24% and it's not 11%. There's not evidence for Texarkana. The words unprecedented and inconsistent come to mind in terms of what the board staff, I think, is asking this board to do with respect to CVS. I asked Dr. Kirtley, has the board ever, he's been here 20 years almost. I asked Dr. Fain, this is the same question. Has the board ever imposed a per error fine stemming from an accuracy audit? Answer was no. That has never happened before, saying, okay, like was proposed at the informal, $250 an error. Doesn't matter if that was a very serious med error or maybe something like not leaving off prescription refills.
But I'm gonna have to object because I again think that's a mischaracterization of Dr. Kirtley's testimony. Dr. Kirtley testified that there have not been any cases before this board at this level due to any accuracy audit.
Ms. Vales, it's closing. He's allowed to characterize the testimony however he wants. Go ahead, Mr. Mitchell.
Yeah, so again,
Objection, overruled.
this board, many of you, Dr. Newsom, of course, y'all been on this board for a while, many of you. You know that's the case, that you have not sat here and said, okay, we're going to fine this pharmacy $250 or any amount based on every single error that was identified in an accuracy audit. It just has never happened, frankly. It is unprecedented, inconsistent. I submit to you that it is important for this board to demonstrate consistency in the licensees and permit holders that appear before it. This board is acting on behalf of the state of Arkansas, and everyone in the state should be treated fairly. We can go back to Constitution. I'm not going to do all that, but everyone has the right to their day in hearing. They shouldn't be punished for asking for their day in court, if you will. This is our court for this. And I think suggesting that CVS should be punished, that it should be assessed some additional extra fees just because they asked this board to do, frankly, what the governor appointed each of you to do, which is to be here and regulate pharmacies, and what the board staff is paid to do. It's their full-time job to regulate the practice of pharmacy in the state. I frankly find it somewhat offensive to suggest as a lawyer that they should be punished for that and there should be extra fees or costs sort of separate and apart from any fine the board may consider, just because CVS or any other pharmacy asked to be heard on something they were charged with. Now, Ms. Vale said one thing, and we've of course disagreed on facts and different things, but she said one thing that I completely disagree about, and that is that this board should not consider, or frankly, it's irrelevant what the board did with the other pharmacies that had almost the same type of thing. I mean, I don't think we've heard any testimony distinguishing legitimately the Anderson situation or the Walgreens situation from CVS, other than the fact that their error rates were strikingly higher than CVS. She talked about the Administrative Procedures Act. One basis for a court to overturn a decision by a board is because the decision was arbitrary and capricious. And what that has been applied to mean is that if similarly situated persons, entities, licensees appear before the board and they are treated disparately without basis in fact, that is a basis to overturn the board. That's the law under the Administrative Procedures Act. The administrative law judge is here and he can advise you on the law. But that was pointed out in her argument, and I have to say I completely disagree from a policy standpoint and from a legal standpoint. I think this board must consider what it does, the message it sends to others. Does this board want to send the message that if you're an independent, you're going to get off lightly no matter what you do, but if you're a chain, you're not? No, I don't think so. My client doesn't think so. But when we look at these data rates, these error rates, and what happened at the informal conferences with Walgreens and Anderson's, frankly, I don't think it leaves any room to conclude anything other than CVS kind of got the raw end of the deal there. Walgreens, again, first informal hearing. There was no evidence presented at the first informal hearing about training that Walgreens had done. You have it in that we have the transcripts. You can look. No evidence whatsoever. They didn't have a Dr. Rowe come their first time around and say, yep, we know we screwed up, but here's how we're fixing it. There was none of that. The boards heard from them and said, look, we need to get to the bottom of this. We need to hear from you. We're going to have another audit and we want to have you have some people come back and tell us what you're going to do. And that's what happened. The board staff and Dr. Kirtley went and did as directed. They performed a second audit. The error rate went from 24%, well, no, 17%, excuse me, down to 9%. And the board heard from Walgreens representatives about what they were doing. Now, Dr. Kirtley, in trying to distinguish the two between Walgreens and CVS, said, well, Walgreens was really forthcoming. That wasn't the case. They said nothing more than CVS did. And Dr. Kirtley wrote an email to his superior a week later talking about how Walgreens didn't answer any questions, that their error rate was 17%, and now here they are pushing for a higher tech rate. That's Walgreens. The board decided to assess non-disciplinary investigative costs against Walgreens, and that's it. Even though the last audit that showed up before the board was 9%, and that was only controlled substances. Anderson's, similar, same time period, audit, 11% error rate, electronic prescriptions included. We've talked about that. I won't beat it again. The board pulls Anderson's in for the informal. Here's from Anderson's. Anderson says they're going to do these things to make it better. And the board said, okay, please go forward and do that. It's just like Dennis McAllister said. He said he thinks that's how a high functioning board works. It works with the pharmacies. I think he was in his own way trying to commend the board there. But the fact is there wasn't another audit at Anderson's. Anderson's was set free there and asked with the stipulation that they want Anderson's to report back themselves on how things are doing better at some point later. No disciplinary action taken. So we have that going on April 6, 2021. And then the very next day, CVS shows up. 5.5%, 5.5%, 8.2%, 7 pharmacists, 6 or 7 pharmacists here. Dr. Rowe is here. This is all on the very first informal. And I submit to you, CVS did not have the opportunity to demonstrate the improvements that it was made, because the only way that we could know that conclusively is if another audit was done. Yes, much time has gone by now. We called Dr. Ellis and Dr. Powell here not to try to explain away what happened in 2020, but frankly, because my client thought the board would like to hear, even if it maybe is not particularly germane to a 2020 allegation, what's going on in CVS today and how they are doing. So I think there were some questions. Mr. Simpson made a question about who can tell me about them. They can't. And maybe that's my fault. That's not Dr. Powell's fault. But in discharging the duties of the board, that's what we thought we needed to do is also give a current picture of how things stand by bringing in the 2 top people for CVS, essentially for this region. So turning finally in conclusion to what CVS is charged with. And I'm not going to read each of the 3 because they're all frankly identical. But again, respondent pharmacy was not adequately staffed during the period of this prescription investigation. Respondents' inadequate staffing contributed to the errors that were discovered during this investigation. Key term there I submit to you when you're deliberating is during the period of this prescription investigation, and that's identified in the notices of hearing that you can look at. That being the dates of the prescriptions that Dr. Fain went and pulled. Then the charges. Respondent is guilty of fraud, deceit, or misrepresentation in the practice of pharmacy in violation of ARC Code Ann. And it says here 19, I think that's supposed to be 17, just a typo, 92-311. Fraud, deceit, or misrepresentation. There been any testimony or evidence about CVS defrauding someone, misrepresenting something to someone, deceiving someone? I submit no. I think the answer to that charge has to be no for all 3 stores. Respondent, the next one, respondent constitutes the negligent performance of his duties, deeming it unfit or incompetent to operate a pharmacy pursuant to 1792-311A2. Again, and setting aside whether these statutes apply to pharmacists or pharmacies, as we've argued, there is no evidence in the relevant dates of the negligent performance of duties, deeming it unfit or incompetent to operate a pharmacy. Respondent is guilty of unprofessional or dishonorable conduct in violation of 1792-311A7. Unprofessional or dishonorable conduct. There's no evidence before the board to support a finding of unprofessional or dishonorable conduct. Respondent is guilty of misbranding a drug due to misleading, false, or inadequate labeling on prescriptions reviewed during the prescription investigation in violation of ARC Code Ann 2056-211 and 2056-211 subsection 1, subsection 6A. Again, we're talking about misbranding drugs. There was questions about opioid proceedings. I think that's what that is talking about. But we're talking about here an accuracy audit when there was a typo or something is left off in a prescription based on a plain mistake by a pharmacist or a tech to allege that they are guilty of misbranding a drug. The evidence, frankly, is not there to support that charge. That's not what that statute is intended for. And I'll leave it at that. In conclusion, I submit there is not evidence before the board, regardless of any views of how things were back in 2020. There's not evidence to support the charges against these three stores during the particular time of the prescription investigations. CVS, as we have said for 3 years, wants to be treated fairly. We want to be treated just how the board treated Walgreens and treated Anderson's, and we ask the board to give us that opportunity. Thank you.
Thank you, Mr. Mitchell. Ms. Vales, do you have any additional rebuttal to your close? Anything else you want to add? All right, if not, let me just elucidate a few points for the benefit of the board. I think I'm not certain whether or not any new members are here. I think Dr. Davenport, you are. So you heard a lot of terminology thrown around, legal terminology. I agree with Mr. Simpson in terms of the arguments that you heard from Mr. Mitchell, the arguments that you heard from Ms. Vale. They are not evidence. They are their arguments in their claims about what the evidence allegedly did or did not demonstrate that was provided over the last 2 days. What you're supposed to base your base your decision on are the exhibits in these two binders, which is the administrative record at this point, and the 6 people that testified. That's what you base your decision on. Mr. Mitchell alluded to the burden of proof, which is the preponderance of the evidence. I've heard that described in a variety of different ways. You can describe it numerically as 50.1% is preponderance of the evidence. As Mr. Mitchell alluded to, CVS doesn't have to prove anything. The burden is on staff to prove the allegations contained in the order and notices of hearing by preponderance of the evidence. I think Mr. Mitchell is correct. You have 3 different orders and notice of hearing. I think for clarity of the record, for the benefit of both staff as well as CVS, you need to make probably 3 separate motions at a minimum on each docket. And I would suggest that you do a motion whether or not the findings of fact and conclusions of law have been proven by a preponderance of the evidence on each one. And then if you find that they were proven, then you can turn to what you think the appropriate penalty ought to be for each docket. When you go off the record and deliberate, if at any time you need to come back on the record, as the chair or somebody else alluded to, I think, we come back on the record and you can ask questions of counsel, of the director, of the witnesses that are still here. That's fair game. Any questions? Mr. Simpson?
Yeah, I just want to get a clarification on the burden of proof. I've also heard it described as a weighing of the evidence.
Yeah.
And if one side weighs slightly more than the other, that side's met the burden.
Yep, another way to describe it is more likely than not. More likely than not, you weigh it, and if that scale tips ever so slightly in favor of staff, then they've proven their case. If it's on the other side, that they haven't. Any other questions? All right. Mr. President, do you want to go ahead and take a 10-minute break before you
I
deliberate?
was just about to ask you if
Yeah.
we could do that.
Yeah.
Thank
All
you.
right, let's go off. Ms. Mitchell?
Dr. Powell has a flight, and so we don't want to remove him and have him not be available, but he has a flight. Dr. Ellis also has obligations, so I didn't want them to leave and the board didn't have questions, so I wanted to make sure that was okay.
Well, I think if we do go back on the record to clarify something, most likely it's going to be on this side, but we could ask you questions, correct?
Oh, yeah, you can
Okay.
ask, and you can ask Dr. Ellis questions.
Okay.
Yeah, but she needs to,
Oh,
if
you're the one that's-
possible,
she's
they
the one
both
that's
have
leaving?
travel to,
Both of you are leaving.
Well, if,
and I can maybe call by phone too. I mean, I know that's
yeah, if
informal,
board
but
council's not done object to it, I think we'd be okay with.
All right, as long as the board doesn't have a problem with it, Mr. Mitchell, I don't have a problem with it either. All right, so you need to catch flight, you need to catch flight. All right, we are off the
Thank you.
record.
Harold, I'm sorry to interrupt you. Harold, I'm sorry to interrupt you. So we're off the record and
You're off the record, you are deliberating.
we're gonna start
And
deliberations.
you are the one that's running the show at this point.
Okay.
So, and everybody does it differently, Mr. President. There are some people that just open it up for discussion.
Right.
And there are other people or other boards and commissions that basically go down the line and ask, what are your feelings? What do you think? How you want to do it is entirely your prerogative. Either way works.
Well, and I'm flexible with how we do that.
Up to you.
I was gonna propose, the direction has been that we look at each allegation, each order notice of hearing separately. And so do you guys want to approach it from that standpoint? Do you want to have general discussion first or just dive into each one of these separately?
I think since the charges are all the same, that we have a general discussion, but then when it comes time to parsing out each one, if there are different, which I think there's one difference for one of them. And then certainly when we're making motions regarding what to do.
Okay.
Do it one by one, but I think they're comparable enough in terms of the charges or even the allegations for that matter.
Has anyone done a comparison between the two to make sure that they line up?
The charges line up line for line. The allegations are similar. They get to a certain point and they begin to diverge. And of course, number of prescriptions considered, audited, and that sort of thing, those vary. So the allegations don't line up one for one, but the charges pretty much do.
Okay. That's the one that's the difference is the two transactions. Okay. All right, so we'll open it up for general discussion then. I want to pick on you, Dr. Richmond, but you've got lots of notes. Do you want to go first?
I've got what?
It appears you have lots of notes. Do you want to go first?
Well, just in trying to. Actually, there is one question that I have that probably requires on the board, on the record.
Do we have to go back on the record now or can we just put it on the side first or do you?
Well, it'd probably be easier to do it first.
Okay, we need to go back on the record, Mr. Munger.
No problem. You let me know. All set? All right, we're back on the record. The board has a question, Mr. President.
I'll turn it over to Dr. Richmond. He has a question for board staff.
Well, this may be self-evident, but, and I think this only appeared in the reports. I don't recall it being in the allegations or the charges, but the issue regarding failure to notify the board of staffing changes within the 5-day period. Is that something we're considering or not?
I don't believe that they were actually charged with that.
Okay, I just want to make sure. That's the only thing I had.
Okay, does anybody else have anything before we go back off?
All right, if not, we are off the record again.
Thank you. John.
You're welcome. Want to proceed with your thoughts?
Well, I'll just start up with immediate thoughts and trying to digest everything that we've heard the last couple of days. Looking at the allegations as they flow through to the charges, listening to closing statements, even opening statements for that matter. We know that in the charges, there are issues related to misbranding, which directly relate to improper labeling or the errors that showed up in the audit. And council stated twice that errors were not in dispute. That would seem to be the case. That staffing was not proven one way or the other in that on one hand, there are no regulations that speak to it, although I think that intuitively, every pharmacist in the room understands that you have to have adequate staff in order to do your job. But the Board of Pharmacy can't quantify it through any regulation or statute. But similarly, although there were many efforts in trying to do so, there was no explanation given by CVS as to what staffing levels were or how they were determined. Or for that matter, even name who determined other than it was above their pay grade. So while staffing is certainly a contributing factor to errors, there has been no direct causative link between inadequate staffing and the errors that showed up on the audit report. And then the big issue regarding differential treatment, and that the fines were unprecedented and that the board acted inconsistent. I don't know that there's any precedent, maybe at least not with this board, simply because it's my understanding that these audits were something that were newly being performed by the board. Now, the fact that they were being newly performed by the board doesn't suggest they're novice or inept at doing so. Because if you have checked a prescription in your life as a competent pharmacist, then you would know how to do an audit. Similarly, given that this is the first time down this road for this sort of thing in terms of looking at the audits and finding on that basis, there can't be any inconsistency either because there has been no formal hearing or findings in that regard. So it leaves us with the audits. And that's kind of where I end up. Now, when you look at those audits, and I disagree with the characterization that the improper labeling does not constitute misbranding. Because if you read the regulations, I think that it entirely does. But if we're going to charge this as an error and it's presumed that all of these prescriptions made it to a patient, but if you went through and said, okay, well, let's only look at the important ones. If you looked at the ones in which there were changed directions, inadequate directions, confusing directions, or frankly, the wrong drug or the wrong strength, those would potentially be serious errors that would need to be considered. So we can either look at these in the whole, of which there were 204 audited errors, or there were 135 that would meet the criteria that I just described. So that's kind of where I'm at this point.
Okay, so I want to make sure I heard you correctly. You're saying in your mind, there's no question that there was misbranding.
Yes.
There's no precedent to establish that there's differential treatment or whatever the terminology you use there. But we also don't have any basis for inadequate staffing.
I haven't seen, I mean, there's nothing that said that specifically, it was characterized that way, but there's nothing specific. There's no standard to hold it to. And unfortunately, CVS couldn't provide it either. So while I think that we, in looking at those pictures and seeing buckets stacked up in all three colors, and that does not seem like normal practice, we can look at it and say, it looks like a duck and quacks like a duck, it's probably a duck. Except I'm not sure that when we are beginning to point a finger at blame, if you will, from a disciplinary perspective, that we can quantify and say, yeah, that's the case.
Well, I would like to just point out real quick before I turn it over to you that, we can find certain allegations not to be found true. And corresponding charges can still be proven, or some charges are not proven. So, yeah, I don't have an issue with that. But I did want to point out that the only charge that I think he really, addressed was charge 4 around misbranding. So we probably have some other ones we have to talk about.
Well, and I did go through in terms of which allegations I found, I thought to be true versus not necessarily untrue, just not, can't say one way or the other. And then there are 2 charges I think that can be shown to be proven. And one other thing, in addition to the audits errors, there were in fact 2 confirmed patient-reported complaints that resulted in injury. So those are important to consider. Plus, as Mr. Simpson said, the 2 Sudafed dispensings are an issue as well.
What are the 2 charges besides C4 would obviously be one of them? What is the other one, the C3?
C3.
But, permanent way. So while that wording is kind of weird,
Agree.
because I think they use it purposely.
Okay, so 3 is unprofessional conduct, dishonorable conduct. 4 is the misbranding charge. And Dr. Mack, you're saying C1 and C2 need additional discussion.
Yes.
Okay.
If we buy Mr. Mitchell's argument that C1, 2, and 3 can't apply because a pharmacy isn't a person, then all we're left with is C4. I disagree with that. I'm not willing to take the license away because of any of this stuff. So I think we ought to eliminate C4, and I think we ought to affirm our belief that C1, 2, and 3 do in fact apply to pharmacies. So that's my thinking on that particular issue.
Eliminate C4?
If we act on C4, my understanding is the only option we have is the only action we can take is to recommend termination of the license.
Well, that wasn't 407.
Maybe we better
Well, we can go
clarify.
back on record and ask that,
We
but
better clarify
in looking
that.
at, and Harold, y'all know you've probably looked at it too, but in looking at 17-92-311.
Yeah.
Am I reading it correctly that the permit holder is mentioned in there? It's not the individual pharmacist, but it's the permit holder?
Yeah, I'm not sure. I just know Mr. Mitchell's argument is that it doesn't, that section doesn't apply to pharmacies, just to pharmacists,
Okay.
which I do not agree with, by the way.
You're talking about 20-56-211?
311.
311, okay.
Not to go with Dr. Richmond. Just because probably absolutely feel like those stores weren't staffed. There isn't a piece of paper or a number that can state that. But just from the looks of the place, you had a good idea that there was. My concern with CVS as the corporation is, and I think they've changed that now, but I think back then, quality and quality on the prescription, following every single thing for the team. They mentioned several times about make sure that we care so much about compliance. Well, that's a great improvement, but I don't believe that you could find that many pharmacies making those careless type, just leaving stuff off. Almost like a lazy pharmacist job. If you read the prescription, you don't put it all in, and if your tech didn't do it and you didn't send it back to them, then that's just a problem to me. And I feel like it was because they probably weren't staffed adequately, and they didn't, from the corporation down, they probably didn't make a big deal about the doctor says until taken, put 7 days, put for 7 days. I don't think that quality check was going down all the way to the pharmacist for that many pharmacists to be doing it. Every pharmacist in the world knows if the doctor said for 7 days, you have to put for 7 days. description. You don't just pick what you want to put and put that. So to me, it's more of a corporate issue that was being allowed.
Going back to the understaffing problem and the burden of proof. You know, I think that clearly there's an implication from the audit that was done, that was made and testified to, that the problems that the audit showed were evidence there was understaffing. There was an implication there was understaffing. Now, let's just say for a moment, that's not much evidence of understaffing, but it's some evidence of understaffing. So here it is. Now we got the question, does that outweigh the evidence that it wasn't understaffing? What's the evidence that wasn't understaffing? There's none. So from a preponderance of evidence standpoint, I think that's the understaffing has been proven by the mere fact of the audits. And
Let me ask you this, though, that whether or not the allegation of understaffing is true or not true, it doesn't change the fact that the audit showed a certain error rate.
Right.
And so irrespective of what caused the error, of which staffing could be one, or whatever, I mean, there could be any number of reasons that an error could occur, staffing simply be one. Even if allegations regarding staffing were not in the allegations, that still does not change the fact that there were multiple errors.
Right.
So the errors stand on their own.
Right.
Whether there was understaffing or proper staffing. I'm not advocating and saying that it looked perfectly fine to me. My point is that in terms of what we're going to make our decision based on, I don't know that we have anything that we have a feeling. I agree. I think we all agree with that.
I
But
agree with you.
we can certainly agree that the errors occurred regardless, whatever the reason.
Yeah, the only difference would be there's a specific allegation of understaffing. I agree. You could strip that allegation out and still reach exactly the same conclusion. That's what you're saying.
Yes, sir.
But what I'm saying is that in addition to that, there is evidence of the understaffing that flows from the audit and the record review that took place.
Or from the testimony.
And from the testimony,
The picture.
carrying it further, right?
Well, and so did we not define staffing as including not just the number of employees, but also the training, the qualifications, leadership, et cetera, Like,
Sure.
so at that point, then it's kind of that's checked, I feel like.
But what do we do with that? I guess I'm not following the so what. I think I agree with what you said, but
It seems to me that the basic allegations were that set forth were uncontested. And that there's been sufficient evidence introduced, call it weak if you want, or arguable if you want, but it's still there. It outweighs the no evidence that was produced. So I think that we're fine in upholding all of the allegations that are made, including the understaffing allegation, which is the only one that really I think is questionable.
I think one other way to potentially look at that is the preponderance based on the evidence is there for the Texarkana store. I think you could question whether, since we had no testimony from any pharmacist that worked at the Bella Vista store or the Sherwood store, if I remember correctly. Well, yeah,
Well,
so our pictures.
You have testimony from the audit, and you have testimony, if nothing else, on what's happening at the other stores, which is a pattern. Now, again, weak. I'm not saying that's the strongest, but is there any evidence that of what the staffing was, that the staffing was adequate, that there was a reason for those errors that was justifiable? There's no evidence to outweigh even weak evidence with regard to those things.
I see what you're saying.
So I'm basically, I just say I'm basically okay on the allegations, upholding the allegations.
You're saying regardless of whether, so we talked about how in the regs there is some specific language for hospitals, but there's nothing for retail. But you're saying the allegation is the allegation and the evidence, even though weak, weighs toward supporting the allegation.
Right. Exactly.
Okay.
Then with regard to the conclusion, what do we call them? Charges. I think we have to make a decision on whether we care about trying to make the C4 charge. And we need to find out, if we do C4, does that leave us only with the option of doing the termination?
So we'll go back on the record. I'll ask you to address Ms. Fales on that. But before we go back on the record, do we want to talk about other things like charge 1, charge 2? Get comments from this side over here? Or do we want to go back on the record now and ask that question? Okay, need to go back on the record. Are we back? Oh, we're waiting.
All right, we're back on the record. Staff, board has a question for staff. I have a huge frog in my throat, Mr. President.
Okay, you're good. Mr. Simpson, please ask your question.
If we uphold charge C4 in any of these cases, do we have any remedy that we can apply, and are we required to apply a remedy of termination?
So what you're talking about, and it's C4 in one of them, but it's the
Right.
misbranding. That one is not directly tied to 407. Staff's interpretation, both myself as a director and legal counsel, I think would agree, does not mean if you have a finding on it that you shall revoke. You would still have the other alternatives to disciplinary action in that instance, because we are trying to frame the whole thing with the 311 section, not solely 407. If there was a charge that said 407 alone and you found it, that's the potential risk of that. And there's some academic argument in the Administrative Procedures Act that there could be an alternative charge, but we are trying to ensure that the board has an alternative charge rather than solely revocation, even in the misbranding.
Well, so then you're saying it's possible for the board to find C1, 2, 3, and 4, and 5 in the extra case, and not take a suspension action, to only take the fine or whatever you call it, the monetary sanction.
Yes, you could do the alternatives, which could be probation, suspension, fining authority, rather than straight to revocation.
Okay, let me ask you one other comparable question. Let's suppose that we do C1, 2, 3, and 4, and a court later knocks out C1, 2, and 3, and C4 alone support the fine action.
I would believe so. They could stand individually. Generally, because all 4 are attached to the same potential violations, I do not believe that we would suggest saying if there's 100 errors, it's 100 in C1 and 100 in C2 and 100 in C3 and 100 in C4 to get a total of 400. If there are variables between the different ones, then yes, I would think our legal counsel's here that you could say the charges are found, and based on 100 charges, we want to do this penalty for the 100 charges to delineate it. I don't believe you have to delineate it by charge, but by the finding of charges and how many violations there were.
Okay, and then one last question. Could we then also say that in the event any one or more short of all of the charges that we find are knocked out later, any one of the remaining charge is sufficient to justify the action that we're taking?
I think you could put it in your motion. I do not know how the court would handle that, but I understand the concept. I think you could put it in your motion and it would be reflected in the record.
I would do that to try to avoid a remand for a rehearing. if one of four got knocked out.
I mean, I've seen those types of protections in statutory attempts. You see it in, wills and other legal issues, but
Mr. Simpson, is your question oriented towards one charge, but you still will be able to level recommended
No.
in the order of notice of hearing? Is that what you're asking?
No, I'm saying you find all four, C 1, 2, 3, and 4. But you provide that each of those charges are independent of the other charges sufficient to support the action.
you're basically saying we're not calculating this much on charge one and this much on
Right.
charge two. The
Right.
one with the extra fifth charge might be a separate thing because it isn't part of the misfills with the pseudoephedrine. But you could say, taking those, any one of the charges would be sufficient for the following action.
Right.
True. Make sure I understand because
I know, he had a little bit of an issue with 311, but y'all chose, I understand completely why y'all chose 311 instead of 407. Does it only pertain to a pharmacist or does it pertain to a pharmacy?
But right or wrong, we have used it for many years
I thought so.
when charging both because of the extra language we have under 311. And if you read just 311A, it talks about permit or license, and we generally think of businesses being permit holders and humans being licensees or registrants. So, it's subject to interpretation. It's one of those art of whoever wrote it originally in legislative research and drafted it and put it through. It's an art of law issue,
Yeah.
completely depending on who the original author was.
Here's the rub of that whole thing. So in the past, when what you're asking, Doctor, is an issue of statutory or legal interpretation, what does the law say? In the past, a board or commission or state agency was given a lot of deference to the statutes that they implemented. That deference doesn't exist anymore based on recent Supreme Court precedent. If it's a matter of law, actually just about a matter of anything, there is no deference given, but certainly for a matter of law, the appellate courts are not going to view what your interpretation is as controlling, and they're going to make a decision based on what they think the law is, if that helps. Now, that shouldn't change your decision one way or the other, but should this be appealed and it gets remanded because the appellate courts don't think your interpretation is correct, don't be surprised. You'd be in the same boat with a lot of other agencies out there lately.
Talking about Chevron?
No. I'm talking about
No.
the state Supreme Court.
But that would be an argument that Dr. Mitch and I would hash out at a different level about
Yeah.
an
Yeah.
interpretation of that
It's-
provision of law.
They basically changed the tapestry of administrative law, but they've been changing a lot of things legally lately. So, yes, sir.
So if, make sure I understand. So if there's no particular, so this much for charge one and this much for charge two and this much for charge three, I guess in terms of a fine, if you're simply collectively considering them, then on what basis do you determine what that fine is? Let's assume that you go with the maximum. If the maximum is 1,000 per charge, or is it per
violation?
per violation?
And if there's I mean, the board has to determine how to build this. But if you say that the example I gave is if there's 100 examples of a violation, you could either say there's this many at this charge and that many at that charge and this many at this charge and add them all up, or you could say there's 100 violations that are reflected in all the charges and just say any one of which would be sufficient for this action. There are instances where you add them up to, I hate to say the word dogpile, but I think it's a good descriptor, to dogpile that you violated multiple things with one action. And there are other times when the board would say this one action actually caused violation of these 5 charges, but we're going to count it as a violation, not 5 separate for the one action.
But the fines we're talking about are case specific. Like, because each of the cases were
Yes.
multiplied by
Yes.
250. That's not the case with expenses though. Expenses are gonna have to be parceled out, are they not?
Well, perhaps, but because these dockets were consolidated, you may be able to get under one umbrella in terms of expenses as well, I think.
We would probably discuss that with their counsel and see how to do that. And if you said, if you directed something like all expenses versus any above and beyond expenses, like we would be able to calculate that as well.
Does that help? All right, you ready to go out, back off the record?
Yes, sir.
Okay, we are back off the record.
Okay. So we got clarification on Harold's question, I think. We want to talk about C1, C2. Okay. So C1 states that respondent is described in A1 through A10 is guilty of fraud, deceit, or misrepresentation in the practice of pharmacy in violation of our code and 7 to 311 thing. Yeah. Yeah. So thoughts on that charge?
I don't really see anything going.
We're comfortable with that?
Mhm.
Okay. And then C2, responded as described in allegations 1 through 10, constitutes negligence, performance of duties, deeming it unfit or incompetent to operate a pharmacy pursuant to Arkansas code.
I think it stands as it's written.
Well, I think that we can say that they were negligent in their actions, but if we were to agree that that charge is proven, that they were unfit and incompetent to run a pharmacy, if we don't shut them down, then that by proxy makes us culpable, it would seem to me, that you have now said, okay, well, the board found that they were incompetent and unfit, but you let them be remain a licensed pharmacy anyway. So that's the part about C2 that I have a problem with.
And I understand that too. But unless I'm misunderstanding my non-legal mind, 311 does not force us to revoke their permit.
Yeah, but these things happen and we have to, yeah.
It's spam.
Another way of saying it. You're not doing a good job. When you say you're unfit,
Well, and I mean, if you are saying that from a legal perspective, then okay, but unless there has a legal definition for unfit or incompetent,
it's,
in a layman's sense, that
it's to us to define that.
I have a problem with that one.
What's the legal definition of negligence?
Yeah, but like I said, these things happen. They did happen back at that date in time. We are now almost 4 years into the future. But I don't know how many of you heard these cases, but they were, it was not good. The cases were not good.
But it talks about negligence, and I tend to think about patient harm.
Yeah, there was.
But was that only on 2 of the 3?
Right.
Remember correctly?
And one was the Ambien for phentermine and the other.
That was Texarkana. Bella Vista had the, no, it was the
Focal and Adderall was another.
Phentermine.
Phentermine Ambien was one.
Texarkana was a focal and Adderall, and that's what we know of.
And
When you
then
start having that many errors,
Bella Vista was the Phentermine, no. Sherwood was the Phentermine.
I'm sure it was
and-
Ambien.
and- Ambien, yeah,
Mhm.
that's right. I don't think there was, we may have to go back on record, I asked. But I don't know that there was patient harm associated with Bella Vista. Does anyone have any other recollection besides that?
I don't have anything written down.
We're not in this session. Like, that could get into it.
Well, I think we do have a measuring stick when it comes to error rate, it's zero.
Right, but like if we're setting a precedent.
I'm not following. Are we still talking about charge three?
C2.
Yeah, two, I'm sorry.
I just think that is a really have like very clearly defined.
I will tell you in this 1 and 2, they use. We've had a lot of discussion about it. But but they use that language really to particularly, so. I think it's just the language thing. There was a reason for that language.
Maybe we can take a straw poll and see what our feeling is on that one.
Yes,
You'll go with the level of the law.
I'm saying yes, but negligent performance of duties. You know, again, probably need to go back and ask legal counsel, but that's failure to perform your duties and meet a certain standard of care from what I remember. I can definitely tie that into the med errors that led to hospitalizations. I don't know for Bella Vista that I could tie it in. That's my thought. Again, go back on it.
what we're missing here is the standard is unfit or incompetent to practice pharmacy by reason of negligent performance of his or her duties. That's the standard. All of that stuff is the standard. So we're saying they violated that standard. We're not having to pick out individual words and say it's this, it's this, it's this. It's a violation of that standard we're saying it's being violated.
So if we're saying that they're violating it, that they are unfit and incompetent.
Unfit or incompetent to practice pharmacy by reason of negligent performance of his or her duties. I think we've got evidence that there's been negligent performance with regard to supervision, overstaffing, whatever.
Okay, then I'm unwilling to leave or give a license to practice to any registrant who is unfit or incompetent. So we'll have to take their license.
Except we have the option under the statute
Right.
not to do that,
Right.
or to do less than that.
But if we'll find it proven, then we just say that it was proven that they're unfit or incompetent, but not going to do anything about it. That's the way it just comes across to me.
No.
Right, yeah.
This has been in a lot of,
We've,
I don't remember exactly. Has been in, and we have had this. But on the other hand, if they use 407.
They're both in the same section. You have to interpret them together. So you've got that in the statute, but then it also gives you the alternative to take an action that's less than termination or revocation or denial. probate. You have to read it all as part of one section.
I agree with you, based on what was just explained to us. And we have found this to be true, on a lot of other permit holders without. Not trying to talk you into it, I'm just.
Yeah, I'm still trying to understand it. I'm not usually this obtuse, but maybe I'm totally missing it.
We can go back on and get that clarified here.
We should go
You'd
back
feel
on and ask
comfortable
what
with
we're
Back on.
All right, we're back on the record. The board has another question that they would like to ask staff.
I guess the question is in relation to charge two, where it says that they're deemed unfit or incompetent to operate a pharmacy permit. Do we have some sort of legal mismatch? Or if we find that to be true, but we don't revoke the permit, or does 311 give us flexibility? You know, you guys heard the discussion, you know what the answer question is.
Once again, going under 311 into the chapter of 300 that leads to 315. First of all, you're saying in this situation, like the board could have a finding that someone is overall negligent and unfit, period. Or you could say and the way that I would think we're charging this as the director is in these circumstances, you did not meet the standard and you were negligent in these instances. It does not mean that you're completely unfit, but at this time, you show that. When you get into 315, which you don't have to charge people with 315, but it gives you the option as the implementation of it, you could also do other types of alternative penalties, which could include future oversight. I mean, you could say, at this time, we're going to do another investigation or oversight or re-audit. You could say we're going to do probation. There are other things. It doesn't mean just because you say they were negligent in the instances as charged that you have to completely suspend or revoke their license. And I get it. It's a harsh word. It's the same thing we used to have. We had a rule that said unprofessional conduct and a statute that said gross unprofessional conduct or vice versa. And people would get highly offended about the difference between gross and simple unprofessional conduct, but we had to cite both due to the inconsistency between the two. And we removed that word gross later because that word had a different level of offensive speak to people, and the board requested it be removed.
Okay.
I just want to read the sentence and let the words hang there. It says that as described in the allegations, negligent performance of its duties, deeming it unfit or incompetent to operate a pharmacy. So they were negligent in such a way that they have been deemed to be unfit or incompetent to operate a pharmacy. That's what it says.
That's in the order and notice of hearing.
Yes.
All right, any other questions from the board? If not, I think we can go back off the record.
Thank you. Okay. Dr. Kraus, do you have any thoughts? Any additional comments?
I think that as far as the charges go,
Dr. Davenport. Dr. Mann.
The way Dr. Kirkley is. Proven, approved.
Ronnie?
Well, I think you know where I stand on two. And I have a question then about one. So it says respondent is guilty of fraud. I don't think we've seen any of that. Deceit. Not sure we've seen that. Or misrepresentation. So misrepresentation of what? I mean, if the prescription that it was misrepresented, that this is how it should have been filled, but this is how it was filled, that's a misrepresentation. That can make me okay with one. I don't know that I've seen any fraud or deceit.
To say or, doesn't say.
It does say or.
And again,
So
that's
if
just,
misrepresentation can be deemed to describe the improper labeling, then I'm okay with one.
that's just the category in the statute. They could, it could just as easily have said in violation of section, what, 311A1 or whatever it is. Those words are just standing for that.
I can live with that one, but two, I'm not. Go with.
Okay. Dr. Newsom.
I am for A1 through A10, true. C1 through C4, proven. You have to look at how the law is interpreted at that time and place and what was going on at the time and place back in 2000, 2001. Because say we're in a different space and time now. We're looking at that. It will not seem that bad, but if you were there listening, all the things that were going on, all the things we heard, it would be fitting.
I'm with Dr. Newsom, all of them.
Okay. I don't know if it would be best to ask for who would be willing to put forth a motion. And then we can talk about how to structure that, or talk about the structure first and
Well,
then,
we've got another issue we need to talk about.
okay,
I mean, so far, all we've talked about are the allegations and the charges.
Mhm.
We've also got the action that we're going to take.
right.
And I'm kind of assuming we're talking about the $250 plus the whatever, plus the expenses.
Well, my understanding is that anything that we decided in the informal, I don't know the right way to word this, we don't have to do the same thing, or we don't even have to necessarily take it into consideration. Yeah.
Well,
That's what we're supposed to do, is start from scratch. Then I guess my recommendation would be to do that.
Yeah.
And start from scratch.
And frankly, I don't think that probation makes any sense. I don't think retesting makes any sense. I think we're talking about taking some action regarding what happened 4 years in the past. And seems to me the only way to do that is through the fine. To send the message that what happened in the past was inappropriate.
I don't know what the motion's gonna be. I know who supports what, so I don't know who to really talk to in this. But, you know, we've,
Are we gonna have a time?
can we go above $1,000 though? Yeah. Well, if we said that was, they sold 2 boxes or whatever of pseudoephedrine. I thought it was maximum $1,000 per violation.
Or anything.
It's for $80.
Right, this is,
Mr. Moulton, we need to go back on the record.
Back on the record, the board has a question it would like to ask staff.
You heard the question.
Hearing it, and I'll clarify it for the record. I understand why there is confusion about finding authority on pseudoephedrine. Due to the fact that many years ago, because the board regulates the wholesale distribution of pseudoephedrine, there was language to fine up to $10,000 on wholesale distribution of pseudoephedrine. Our understanding would be on the retail sale of pseudoephedrine, the $1,000 cap would apply. And because it applies to everything else in our stuff other than wholesale pseudoephedrine.
What about the patient?
It's still a med error. And so, yes.
All right, any other questions? If not, we're off the record.
So now that we've got clarification there, do you want to? $1,000 per what? You said the two Sudafed, the two patient med errors. Are you talking about the audit results or are you talking?
So you're saying $1,000 for 204 errors, so $204,000?
That's, I don't have a vote. That. My feedback is I feel like that's. I feel like that's heavy. Well, I feel like it's heavy handed. That's what I was gonna say. I mean,
they were $500 in the.
250.
That was my categorization. There's a total of 204 reported errors out of the cumulative audits. So each of the errors would be levied at the store level for this amount for this store.
What was the 135 though that you noted?
I went through, I excluded things like the wrong doctor's name or something like that. But I only included wrong drug, wrong strain,
See, I broke it down.
and incorrect direct. So based on that, there were, instead of 72, there'd be 46 for Texarkana. Instead of 26, there would be 18 for Sherwood. And instead of 106, there would be 71 for Bell Vista.
Well, I always saw that.
But we're
I-
rating them.
I always saw the 250 kind of as being a compromise to take into account the range of things. If you want to go just with the more serious ones, then the multiplier number needs to be larger.
That's what it cost.
Yeah.
I just hate for us to get in the business of well, this one's
Right.
every one of them.
Mhm.
Yes, they're milder wrong, but they're still wrong.
They're still rolling.
It seems to me, looking at it just from a fresh, since I wasn't a part of the original, that the original committee got it about right. With the 2,000 plus the 250 per. Yeah,
It's
it's about 90,000.
60, it's $78,200. It was broken down 29.4, 29.4, 19.4. I don't know if I wrote that down wrong or not. For a total of 78,200 plus 10,000 per complaint. I don't know how we got to the 10,000 per complaint when we've established that it's 1,000, but that's what I wrote down. I think that was from opening remarks. So the two patient errors, that's not, is that included in the 204 or the 135?
I don't
That's
think they
separate.
were. I mean, there's no evidence to suggest whether they were or they weren't.
Okay. So you,
Yeah, the
you
errors
got
were-
204/135. And you got two for the harm to the reach the patient. And then you got two cells of Sudafed without pharmacist oversight. Am I missing anything?
investigative costs.
So what is the will of the board? And how we structure this? I guess first I'll ask 204 versus 135. Okay. And then we agree 2 and 2. Okay, so
Well, but
let's,
remember, you gotta do it by store.
we'll break it down. So can you call out the breakdown for me on the 204?
72 for Texarkana. 26 for Sherwood. 106 for Bell Vista. And then you got one patient complaint at Texarkana. And one patient complaint at Sherwood. I forget which store it was that Sudafed was at.
It was Texarkana.
So then two Sudafed at
That was
Texarkana.
Bella Vista. No, let's go back and look. Just go back and look.
Yeah, it was Bell Vista.
Bella Vista. Okay, so that's 73, 27, and 107. And what was the amount? What was the amount that that you guys? Was it? But so I got 18,250 for Texarkana, 6750 for Sherwood, and 26,750 for Bella Vista. 250. Let me double check myself. Yep, that's correct. I don't know why the dollar amount's different from what happened in the informals, but
We didn't do 10,000. Yeah, I don't know.
well, but even separate from that, there was 78,200 plus 10 plus 10.
Maybe the patient, was that the patient harm?
Oh, you think it was 58,200 plus the 20? Okay.
Because both of those errors resulted in harm. And I think that's why there was a larger charge there.
I think you're right. 51,750 would be the total there. Still not adding up exactly right, but. Okay. And you mentioned investigative costs. You said 45.
But what's our total so far?
51,750. $45,000. Oh. Typically, we've done investigative costs on non-disciplinaries, right? Or have we rated them? I mean, this is kind of, this is disciplinary, so. But the statutes say that you can recruit investigators. It doesn't say. But we've already been given the 580 hours. When I added up, 200 plus 60 plus 80. No, I've got it. I wrote it down. Oh, okay. Awesome. Can we go back on the record, please, sir?
We sure can, Mr. President.
Hearing the discussion and this.
Hold on, hold on. All right, not quite yet, Director. All right, we are back on the record.
Hearing the discussion, and I would tell CVS council the same thing. You know, we don't disagree with trying to calculate the out-of-pocket part of this. Part of what I was talking about was how much we had invested in it. A lot of that is staff salary time. Generally, the out-of-pocket, which we won't know the full impact of until this meeting is over and we get all of the billing in because of witness travel and other things. But it would be the out of ordinary travel for the investigation itself, either to perform the audit, which would be out of pocket because we have to reimburse that, the travel of the witness and the cost of putting on the board meeting, court reporter. It's those costs, which it's not $50,000, but it's probably $10,000.
So in terms of motion, can we make that based on the calculations
of staff of the out-of-pocket cost as described, not straight salary time? Okay.
Mr. President, board members, just for your benefit, and I'm sure I'm beating a dead horse to a certain extent because I know, at least as far as Dr. Newsom goes, she's been through this a lot over the years. But in terms of framing your motion, I'm just going to give you like rhetorical. So I've got the Bella Vista matter up first. So I would recommend that your motion be something along the lines of somebody makes a motion that the allegations contained in A1 through A14 and the charges C1 through C5 were proven by a preponderance of the evidence. You take a vote on that. And then in terms of what your penalty would be, somebody makes a motion in terms of a settled penalty and then what you want to assess for your costs, if you want to do that. That's probably the best way to go in terms of clarity. Of course, it could be a situation where you find that the allegations, you make a motion and find the allegations A1 through A11 were proven by a preponderance of the evidence, but A12 through A14 were not proven by a preponderance of the evidence. But that's kind of the structure that you're looking for. And it's probably the way you've done things already in the past, but
I don't know that I've ever had 3 order notice of hearings in one hearing.
And I think it's important because there seems to be a little bit of disagreement among the board. Maybe not, I don't know, I can't quite tell when it actually comes for a motion. But the more clarity you get in terms of your motion, in terms of what you're voting for, the better it's going to be for everybody involved.
So would you recommend potentially 4 motions, 1 for each order notice of hearing and 1 for the monetary component?
I'd actually, you could do it that way, but.
I think you're
Director?
really suggesting 2 for each.
Yeah, I'm actually suggesting you do a motion on allegations of fact and conclusions of law. That's number 1 for each, for per case. And then a motion on what the penalty ought to be, if that makes sense.
Whatever action you take
Right.
as a second sentence, because it would
Right.
help us to reduce it to writing that way as well.
So yeah, let me just give you a rhetorical. So Bella Vista, motion would be, make a motion that the allegations of fact contained in A1 through A14 have been proven, or A1 through A14, and the charges C1 through C5 have been proven by a preponderance of the evidence. You take a vote on that. There'll be a second. And then based on those findings, make a motion that a civil penalty of $20,000 be assessed and costs of X amount be assessed as well.
Okay.
And then a motion, and then a second and
So it's
a
gonna be
vote.
6 motions total.
Exactly.
Okay.
Yeah.
Understand now.
Does that help?
It does.
All right. Apologies if I intruded in your deliberations
good
here.
guidance.
but- Yeah. All right, we're off the record.
Okay.
Are you, do you? We were talking about that. Oh, I'm gonna, yeah. Do you want to talk about it? 250 versus something else, because they're going to. That's what I'm asking.
You mean 1,000 times what?
Would technically be 206. I'm sorry, 207.
And that's the total number of cases that fell out in the 3 audits combined. Okay.
The question is 250.
Yeah.
Okay, so I know your opinion.
Well, Harold suggested against what my emphasis usually is, which is written plan of correction. I generally don't give, I usually go with the crowd as far as the fees, so I haven't really given any thought to that.
You're thinking what? I'm sorry.
I said, I haven't given, I don't have a number.
Okay.
Oh, no, 5.
She said what?
500.
I'll go with 500.
Okay, so we got 500, 500, no opinion. I remember you were. Yeah, and then Debbie, you said 500. Okay. All right, we'll redo the math here.
What I said was I don't have a number. I was simply explaining why I don't have a number. That's all right. It's not important.
So it might be for her. He usually. Or quite a,
And you don't want that.
Well, it's not that I don't want it, it's just been
He probably
recommended
was
against it, given the time and.
How far?
years
Okay.
ago. That's how he.
Are we ready to make a motion? Or 6 motions? I've got the math here. I'm just waiting to see who's gonna.
If you've
If-
got the math, I can make the motion.
All right, Harold, do you want to write these down or?
Yeah, what is it?
So your Texarkana is gonna be 36,500. That is 73 violations at $500 per. Okay. Sherwood will be 13,500. There's 27 violations, I'm sorry.
Okay.
Bella Vista will be 53,500.
I'm sorry, how much?
53,500. And that's 107. And then I guess what I would recommend is you do a third of whatever the board calculates as the investigative costs above normal salaries, or however you want to word that. Just do a third per store to get that in. That sounds good to you.
And I don't see any reason we can't do each one of those just do 3 total motions. Got everything we need now.
Per store, do the fine and the
Yeah,
allegations and charges all in one.
yeah, why not? No, we got it.
Okay. Everybody comfortable with that? I think we did get some advice that maybe we would make it 6, but are you saying? What we historically do is we find the allegations and the charges.
Yeah.
Proven true, and then we also state the board action in the same.
Yeah, sure.
So if that's what you're gonna do.
Yeah, we got the
I'm
numbers.
okay with that.
The only thing I would add is I would add a provision that said that each one of the charges is sufficient to stand on its own and support the number.
Okay.
Okay.
I think we're ready to go back on the record.
We'll start with Texarkana.
Whatever order you want to go in.
That's it. All right, we are back on the record. My understanding the board has reached a decision in these matters. I will turn it over to the president for motions and votes. Mr. President.
Okay, so we have 3 separate orders of notice of hearing for CVS. Can I entertain a motion?
Yeah, I move that the board make the following findings of fact and conclusions of the law and take the following action in the matter of CVS Pharmacy number 10019, Texarkana, Arkansas, AR 20686, case number 2020-105. Board finds that allegations A1 through A10 and charges C1 through C4 have been proven by a preponderance of evidence. The board further finds that each of the charges set forth in C1 through C4 in the order and notice of hearing, independent of the other charges, is sufficient to support the action taken below by the board. The board takes the following action by adopting a civil fine in the amount of $36,500, computed as 73 uh,
Violations.
violations, times $500. And is there a $1,000 on this one? I don't think so. I think that's it. And in addition to that, assesses 1/3 of the board calculated hearing expenses as determined by the staff with regard to the 3 combined hearings, 1/3.
I added those in.
Does that do it?
Yes. Added the patient harm and the Sudafeds into the total number. Additive to the, just to give it all, so we didn't have to break it down, correct? Okay. So we have a motion on the floor. Do we have a second? We have a motion and a second. Any further discussion? If not, all those in favor, please signify by saying aye.
Aye.
Any opposed?
No.
We have 5 ayes and 1 nay. Motion passes. For the store in Sherwood, is that okay? I would like to entertain a motion.
I have a motion. In the matter of, the board makes the following findings of fact and conclusions of law and takes the following action in the matter of CVS Pharmacy number 10430, Sherwood, Arkansas, AR 20768, case number 2020-104. The board finds that the allegations of the order and notice of hearing, A1 through A9, and charges C1 through C4 are proved by a preponderance of evidence. The board further finds that each of charges C1 through C4 set forth in the order and notice of hearing, comma, independent of the other charges, comma, is sufficient to support the action taken by the board. The board takes the following action of assessing a civil penalty in the amount of $13,500 computed on the basis of 27 violations times $500 and assesses 1/3 of the staff calculated hearing expenses for the 3 matters tried together.
We have a motion, we have a second. All those in favor, please signify by saying aye.
Aye.
Any opposed?
No.
Have 5 in favor, 1 opposed, motion passes. Need to make a correction on the calculations for Bella Vista. It's 54,000, not 53.5. I missed
54.
54, yeah. We haven't made that motion yet. Yeah, I'd like to enter in the, in regards to the Bella Vista CVS store, I'd like to entertain a motion.
I have a motion. I move that the board adopt the following findings of fact and conclusions of law and take the following action. The board finds the allegations A1 through A14 and charges C1 through C5 of the order and notice of hearing have been proven by a preponderance of the evidence. The board further finds that each of charge C1 through C5 set forth in the order and notice of hearing, comma, independent of the other charges, comma, is sufficient to support the action taken by the board. Board takes the following action. It assesses a civil penalty of $54,000 computed as 107 violations times $500 per violation, and 1/3 of the staff calculated hearing expenses for the three matters heard today combined.
Mr. Simpson, the number was actually 108. Would you be okay with amending
Yes.
that motion?
108. Okay, yes.
Do we have a motion? Do we have a second?
A second.
A motion and a second. All those in favor, please signify by saying aye. Any opposed?
No.
We have five approvals, one nay. Motion passes.
Mr. President, I will note, the board passed all three of them by a vote of 5-1. I will request staff to reduce the board's decision on all three dockets to writing. Make certain that Mr. Mitchell and Mr. Smith get a copy of the board's decision along with some sort of information sheet or cover letter that notifies them of their appeal rights. If there are no further questions or comments, I will call this hearing to a close. Thank you all very much.
Thank you.
We have nothing else for you today unless any of you have anything.
Now, do you need a motion to adjourn?
Oh,
Any opposed? We adjourn.
thank you.